Hello. Good afternoon to everyone present here. We request you to kindly settle down because the session is going to start soon. We request everyone to kindly settle down and put your phones on silent, please.
Hi, please occupy the seats in the front. Whoever is entering the hall at this moment, please occupy the seats in the front.
We take great pleasure in welcoming you all to today's first panel discussion on the vital topic of balancing journalistic freedom and legal boundaries, navigating censorship, regulation, and responsibility in digital media. We're honored to have with us three esteemed experts who bring diverse perspectives to this important conversation.
First, we'd like to welcome Ms. Dhanya Rajendran, co-founder and editor-in-chief of the News Minute, a digital publication that covers South India. Ms. Rajendran has a body of work focusing on politics, human rights, gender-based violence, and disaster coverage. She was a recipient of the Chameli Devi Jain Award for the Best Woman Journalist of India in 2022 and is also the recipient of the Reading Journalist of the Year 2023 by the Mumbai Press Club.
Next, we are pleased to have Assistant Professor Sudeep Sudhakaran, an Assistant Professor of Law at St. Joseph's College of Law, Bengaluru, specializing in labor rights and human rights. Alongside Sir's academic work, he is an active commentator on political and social issues, using various platforms to share insights and engage in public discourse. I welcome you to the panel, Sir.
We are also joined by Alok Prasanna Kumar, co-founder and lead for the Vidhi Center for Legal Policy, Karnataka. His areas of research include judicial reforms, constitutional law, urban development, and law and technology. Mr. Kumar writes a monthly column for the Economic and Political Weekly and has been published in the Indian Journal of Constitutional Law and the National Law School of India Review, apart from media outlets such as The Hindu, Indian Express, Scroll, Quint, and The Caravan. Welcoming you to the panel, sir.
Finally, let me introduce our moderator, Dr. Jacob Joseph, Assistant Professor of Law at the National University of Advanced Legal Studies. With over 16 years of teaching experience, Dr. Jacob has pioneered innovative courses on food law, fisheries law, and national security. His expertise in bridging legal theory with practical application will be crucial in guiding today's discussion on the intersection of media freedom and legal regulation.
We look forward to an engaging and thought-provoking conversation as we explore how media professionals and legal experts can collaborate to balance the freedoms and responsibilities in today's digital landscape.
Thank you, and welcome once again to all our panelists and attendees.
Very good afternoon to one and all, and welcome to what promises to be a very thought-provoking session on the theme balancing journalistic freedoms and legal boundaries, navigating censorship regulation and responsibility in the digital markets. So journalistic freedoms, as you know, is a cornerstone in democratic societies, and it's something that is essential for maintaining transparency, for fostering informed public discourse and supporting accountability, public accountability also. And the arrival of digital media has further democratized this kind of the freedom, the journalistic freedoms, in a sense that they have been providing alternatives to the traditional modes of journalistic adventures. And this session would look at how we can balance journalistic freedoms with the kind of the legal boundaries that exist, particularly in the context of regulation and censorship, and how to ensure accountability without stifling the journalistic freedoms and ensuring that journalists and the media are able to freely exercise their journalistic freedoms as envisaged by the constitutional framework. And I look forward to this engaging discussion. And in this session, we are fortunate to have an esteemed panel of experts who bring diverse perspectives from public policy, journalism, and legal academia. So what we propose to do is we'll have around 15 minutes of sharing of expertise and perspectives from each of the three speakers. And at the end of the third speaker, we'll have a Q&A session for roughly around 15 minutes. And so if you have any question, you can note it down and engage with the speakers, the panelists, towards the end of the session. So at the outset, let me invite Dr. Sudeep for sharing his perspectives. You can either sit or go to the podium as you wish.
Thank you, Jacob, sir. Okay, first of all, I know that this may not be a great time to talk to you. I'm a teacher, so I exactly understand the student mentality that you guys will be very tired for a long lecture. So I'll try to present what I think about this topic in a very brief manner. So when we talk about journalism in India and the press in India, I think we need to have the discussion starting from the colonial history of India and how journalism and press played a role in the colonial Indian history. When India was colonized in the late 18th century, 19th century, and later half of the 20th century, initially the colonial masters were not completely against Indians having press or Indians having a kind of press freedom, because they had an idea that they need to kind of a white man's burden, that they need to work among the Indians and to take them to a civilized lifestyle. So because of that, they thought that press, journalism, and kind of things will help them also in satisfying their ulterior goal of civilizing, or the white man's burden of civilizing India. But sooner they realized that if we give such rights to Indians, there is also a greater problem that some kind of critique of the existing regime can happen in this medium. So one of the first regulatory law in India is in 1824. In 1824, the colonial administration, you have to remember that even at that time, it was not like the colonial administration of the later half of the 19th century, because still it was the British East India Company that was ruling India, not directly from the crown. So they introduced one of the first license system in India for press. And interestingly, if you look into history, you could see some interesting developments right after that 1824 license Raj initiated by the British administration. That one of the earliest reformers in India, Raja Ram Mohan Roy, he had a press at that time, a newspaper called Miratul Akbar. So he was writing about the social concerns and issues and things like that. Immediately he wrote a petition after this ordinance being passed by the British. He wrote a petition to the Supreme Court of that time, located in the Fort William, that if any ruler is concerned about what is happening in his country, he should always listen to the media, and media is the best, or the press is the best way to understand what are the concerns in the society existing. But anyway, the British went ahead with their legislation. And finally, in 1 year later, Raja Ram Mohan Roy had to shut down his paper, Meratul Akbar. But later, one of the major second milestone in the regulation of press happens in 1868. When 1868, things have changed. There was a huge revolution against the British in 1857. And after the experience of the 1857, the British realized that we need to further control Indian press. Because Indian press is building a kind of national consciousness which is against the British interest among the native subjects. But the most draconian British colonial legislation comes in 1878, called the Vernacular Press Act, which was the major milestone in Indian license Raj, in my opinion, in order to curb the vernacular press. Because at that time, vernacular press had more number of press and houses than the English press. So why I'm saying this is because when we think about the media freedom or journalistic freedom in India today, we need to think about the role played by media in Indian history, especially press in Indian history. In my opinion, at least in 4 or 5 ways, you could see a kind of influence by Indian press. The first and foremost, in my opinion, is building a kind of national consciousness. Because we need to remember that history when a scattered, 500, 600 entities, to build a kind of national consciousness. And it's also playing the role of unifying. When I say unifying, it's not just a pan-India unification. Sometimes even within the linguistic basis, many of the early press in India were vernacular press. So even in the linguistic basis, to build a kind of unity, it played a huge role. It was also a place in which Indians could have political debates among the various concerns, policies, or other issues of that time. It also gave them a platform, which is also very important because we were a colonized country, colonized people. We were not having such platforms. And finally, and most importantly, it was the place of exposing the colonial rule, especially the ways in which exploitation of the natives were happening. So this history, if you look into this history, you will not find even a single stalwart leader of our national movement without working as a journalist or working as an editor or even starting a newspaper. You take Gandhi, you take Nehru, you take any person, Tilak or any person, you'll see somewhere they would have worked as a journalist during their political action. Because that was the kind of impact journalism and press especially had in Indian society. And I'm not going to the details of the constitutional protections related to press and all those things because you're all familiar, you're all law students, so I'm not going to those things. But what I want to make here is that the constitutional protections for press is a direct result of the experience we had during the national struggle for independence and the way British administration tried to curb Indian journalism. So now when we come to the present days, this history is very important, but anyway, when we come to the present days, we have to have a contextual understanding before understanding the legality of the regime surrounding the digital media. A few things I just want to mention here to set the context of this discussion is that, first of all, we need to understand how the world see press freedom in India. When you look at some of the statistics or some of the surveys related to press freedom. We have one of the lowest rank among the developing countries in the world. If you look at the latest press freedom ranking, India's rank is 159 among 180 countries in the world. When we look at some of our very problematic neighbors, even they have somewhere better ranking than India. You can always question the ranking system and all these things, but at the same time, this is a perception existing in the world related to the press freedom in India. And especially when we think of digital economy, the digital press and the digital media and all these things. One contextual information we should not miss is that we live in a society where the most number of internet shutdowns are happening. In 2023 itself, in India, there was almost 120 internet shutdowns. This is a phenomenon that never happened even in Indian history, as well as when you compare to the other countries in the world, never happened anywhere. And also something we need to think as a contextual information is that the attacks against the journalist, especially physical attacks, as well as legal harassments against the journalist, are on increase in our country. I think this is the context in which legal regime surrounding digital media has to be discussed. So I'll just briefly mention what I think about the regulatory mechanism existing in India and around the world. First of all, when we talk of the digital media, there is a kind of understanding among people, or a wrong understanding in my opinion, that it's an unregulated area. So the government or the body responsible should come up with certain regulations to regulate it. But actually, this is not the right way to approach. In my opinion, there are already existing a plethora of regulatory systems in digital media. I want to start with, some of you might be posting on social media, making reels, and I'm not ready to believe that the college students not making reels. So you might be making a lot of reels and all those things. So can you think how many ways in which you might be controlled by already existing regulatory mechanisms? So one of the major ways in which any person, especially when you do something on social media, is being controlled is by the platform itself. So when internet became popular, I mean, after in Indian context, internet is rapidly becoming popular after Jio giving, such low rates of internet, and also during the COVID time, internet became that popular. But even before that, globally, when internet was becoming popular, there was an idea that internet is going to bring freedom to the oppressed people throughout the world, especially when you are under a dictatorship and things like that. But this particular dream sooner shattered in the world. One of the pivotal moments of this particular dream was that during the Egyptian revolution, the Arab Spring. During the Arab Spring, there was an idea that a revolution is going to be tweeted by the people. But this idea sooner shattered throughout the world. Because first of all, we realized that it's not going to have, thousands of different social media. In social media also, there will be a kind of a monopoly. Now, when you look at your social media, Meta, Google, and Twitter, X, that's controlling most of the social media today. So social media, first of all, there is a monopoly of social media happen. Secondly, prima facie companies are not created to companies is to build a business model in which people will be allowed to interact, and during that traffic to convert that into some kind of for the business. That's the business social media. So forms, I'm coming to the regulations existing. Social media platforms comes up with lot of regulations. Sometimes, I don't know whether any of you are serious content creators. When you go to YouTube, many of the time we read all this fine text. But when you read the fine text of YouTube, you'll find that the government is very, democratic, way more democratic than the YouTube or the Instagram. So on the platform itself, you have n number of restrictions and regulations. Sometimes it is against even the progressive ideas some of the platforms are projecting. Secondly, you have all the existing laws in the country which is regulating digital media. It's not like digital media is not regulated because there is no special law or special legislation or anything for that. Your IPC, your IT Acts, your all the existing legislations, they are all controlling what you're doing in digital media. And thirdly, and most importantly, especially in certain political conditions, people themselves will be regulating. A kind of self-regulation will be happening in social media and your digital platforms. So what I want to, as a summary, I'll not take a lot of time, as I want to say is that, first of all, to understand the digital media and the journalistic rights existing in India today, we need to understand the historical experience. Secondly, what I want to mention is that the idea that it's an unregulated place is completely wrong. The platforms, the society, the existing laws, and all these things are regulating the digital media already. And thirdly, you need to look into the present condition, the political reality in India in which journalism is functioning. And maybe in discussion, I can come to the exact regulations and the political and the other context of those regulations. Thank you.
Thank you, Dr. Sudeep, for that insightful presentation. May I request Ms. Dhanya Rajendran to share her perspectives on this challenge of balance journalistic terms and legal boundaries.
Thank you everyone for joining us in this afternoon session. Like Sudeep was saying, when we have a meeting, we tell, bring bodies into the room. Somehow bring bodies into the room. The minds are not there, but just bring the bodies so it looks like there are enough people in the room, but they're actually not there. So let's not be bodies. Let's also put our minds into it and look at media, entertainment, freedom. I'm Dhanya. I'm a journalist, but I'm primarily here not just because I'm a journalist. I'm also the chairperson of an association called DigiPub. DigiPub is India's first association for digital media. We started in 2021 because of Modi government's urge to somehow control the digital media was becoming very apparent at that time. So therefore we realized that we have to come together as an association. Today we are one of the biggest associations with around 100 to 120 members. I can rattle off many names, but I do not know what young people read anymore. So we have websites like the News Minute, which is mine. There's News Laundry, The Wire, Scroll, Quint, Alt News. The names you would know perhaps, Ravish Kumar, Barkha Dutt, Dhruv Rathi, all of them are part of DigiPub. So we try to come together to see that if there is a problem which digital media faces, then the association stands with journalists. So I started my career 20 years ago as a journalist, and I worked for this news channel for around 8 to 9 years, where my job was to ask every day, the nation wants to know. And then I realized after a few years, after 8 long years, that the nation doesn't want to know, which is when I left TV and I joined digital. So initially, even in my digital days, what would a journalist be bothered about, right? A journalist is bothered about news, about perspectives, about talking to people. So those days we used to have BlackBerry. I don't know, have you guys even seen a BlackBerry? Has anyone seen a BlackBerry? Yeah, so we used to have these BlackBerry groups in which, by the way, our editor was not part of, so it was quite calm. Then by the time I started the News Minute, WhatsApp came. So our groups would be in breaking news from this place, that place. Today, if you take my phone, it's no longer news groups. We have policy groups. We have legal groups. Because half the time is now spent fighting with either the union government, some other government, corporates, people who just want to take us to court. So I'm no longer just a journalist. I also have to have a battery of lawyers. I have to speak with people about policy. in 2021, this is the first time that I believe the government struck with a policy, which is the digital media regulations. But let's not forget the chronology, as we say, right? Chronology samjhiye. What was the chronology? Before the digital media rules were brought in, there were multiple press meets called by the union ministers of that time, and they kept saying that digital media has to be regulated. One of the main reasons they kept giving is that women and children are at the receiving end. There is a lot of child pornography on the internet. Therefore, we have to ban it. You go back to any of those press meets by the INB minister, and I think there was one press meet by 2 ministers together. They kept repeating this. Now, when anybody talks about child pornography or child sexual abuse material, you and me as a law-abiding citizen will believe, yes, law has to be brought in to make sure there's no child sexual abuse material on the internet, right? But when the digital media rules finally came in, it was to define people as intermediaries. And it defined news organizations as intermediaries. So I, along with the Wire, the website, we were the first ones to go to court. We went to the Delhi High Court. But after that, a number of cases were filed. I think Live Law, a website, went to the Kochi, went to the Kerala High Court. T.M. Krishna, the singer, he went to the Chennai High Court because he said it's not just the news organizations which are impacted, it's people like me who consume news who are impacted. Because when you try to regulate news, eventually who is at the receiving end? It's the people of the country, right? Because you are only getting very refined news or versions of news. So he went to court, then I think News Laundry went to court, the Quint went to court. A lot of people went to court, and finally there was some sort of relief from various courts where sections of this law were stayed. We had silence for some time from the government because they were also unsure of now what to do. But it's not like they did not use the IT rules. When the BBC documentary came out on Narendra Modi and the Gujarat riots, these very rules were used to block the documentaries. So while there was a stay, the government looked like they were taking a break, but they actually did not. And then suddenly, 1 or 2 years later, they include this amendment into this into this digital rules, which said that government can introduce fact checkers. What is fact checking? If I, as a news organization, write something about the government policy, which I criticize, the government will fact check me. Now, I can go on like for an entire day about that handle called PIB, which is Press Information Bureau. Sometimes they do these marvelous fact checks, which are so wrong. If you go to PIB, you can actually see those fact checks. They are not factual. In fact, they are blatant lies most of the time. And they have fact check stories which are actually true. There was this journalist, Somesh Jha, who at one point of time, I think before the elections in 2019, he had brought out the how India's unemployment rate had gone up. And so many ministers, from Smriti Irani to everybody, gave statements saying that this is completely not true. We are fact-checking this journalist. There is no data like this, because it was just time for election. The data was never officially published by the government, and eventually Narendra Modi comes back to power. The data is put out on the day that his cabinet is announced. And what was the data? It was exactly what Somesh Jha reported in the Business Standard. But by then, he had been falsely fact-checked by everybody in the government. Now, the problem with anything authoritarian or fascist is that if one government tries it, everybody else wants it. So yes, the union government brought in this fact-check thing. Then Tamil Nadu has a fact-check unit now. The only difference which the DMK claims that its fact-check unit has is that it merely fact-checks. Like if I do a story they don't like it or they think is factually incorrect, they will put out a post. But they will not ask an intermediary to take it down, which is they will not ask Google or YouTube or Facebook to take down my stories. They don't have any powers like that. Then Karnataka, which is a Congress government, is also trying to bring in a fact-check unit. We are not very clear as to where it stands now because they have brought in one part of it, but not entirely. So this is the problem. Once it begins, there is no end to it. So now the fact-check unit, this very ambitious plan of the government, has been struck down by the Bombay High Court, thankfully. But we cannot rest, because in between that came the broadcasting bill. Now the broadcasting bill in itself is problematic, but the way the bill was bandied around is even more problematic, right? For example, nobody had a copy of this bill for the longest time. then Alok can correct me if I'm wrong, but I think finally when the bill was distributed, it was given to certain stakeholders with a watermark on it. So if you are one of the stakeholders and I as a journalist show this, then the government will know whose watermark is it. So there's a specific watermark apparently for each person. One of my colleagues actually had to sit down with somebody who had this draft, write down the entire thing, after which DigiPub could give out a statement, Editors Guild, etc. After all the protests, because this time the government made angry not just the liberals or the progressives, they made angry even the right-wing guys. Because anybody who's a content creator on the internet was going to be impacted by the broadcasting bill, which is like a license, Raj. So for example, if you have a YouTube channel, or if you have a travel channel, you forget news. If you have a travel blog, you have to have a content, I think it's called a content panel. Yeah, you have to have a content panel for your own channel, where you have to have two people who will look at your content and they say it's okay, and then you will put it on your YouTube channel. Can you imagine the amount of work for someone who's just walking around this road and they think it's a beautiful place to have a holiday and a picnic, and they do a video? They have to give it to two people who look at the content and say, yes, this is very good content, put it out. So everybody opposed that. Finally, the government has taken it back. But we cannot rest again. Because 2 or 3 days back, again, a new thing has been sent to us saying that there is going to be a consultation for the National Broadcasting Policy of 2024. As of now, it looks like it is only for OTT, which is the movies that you watch in Netflix or Amazon Prime, which are already watered down, will be further watered down. But we don't know what is the next weapon. So, long story cut short, have you seen these zombie movies? Where you kill one zombie, the next zombie comes, then another zombie comes, and finally like lot of zombies come together, and you can't just kill all of them, so you become a zombie yourself. I sometimes feel like that. There's one zombie, then the next zombie. So half the time, other than reporting news, I have to also be a litigant in these cases. And then we have to have multiple, lawyer meetings. So I really wish that we had a time when I can just be a journalist. And I also want to thank the lawyer community in this country, because without them, we would have been in deep trouble. I mean, without lawyers who still believe in upholding the Constitution, in rights, in fundamental rights, it would have been very difficult for many of us to continue doing the jobs that we do. So please become bright lawyers in the future who also do free work for journalists, because we really don't have money to pay. So I hope you will all grow up and become those kind of lawyers. Thank you very much.
Thank you, Ms. Dhanya Rajendran, for that sharing of your perspectives. In fact, Ms. Dhanya was highlighting the various frameworks through which the executive tries to stifle journalistic freedoms and the necessity to redraw the legal boundaries that currently exist. Now we have Mr. Alok Prasanna to share his perspectives on this topic.
Thank you very much. It's an honor and a pleasure to be speaking here at Nuals, Kochi. It's always a pleasure to speak to young law students who have given up their post-lunch nap to be here and listen to us. I know I can say that with confidence because I was the law student who didn't always give up my post-lunch nap to listen to someone talk. So thank you very much for being here. This is a complete coincidence, and I had no idea that Dhanya would be making a reference to a zombie movie right at the end of her talk. But I'm going to start my talk with a reference to another zombie film. Well, not a film, it's a TV series. Anybody here has seen The Last of Us? Yeah, lots of you. Fantastic. Those of you who haven't, don't worry. This is not a spoiler. It is literally the very first scene of the show. You have 3 people. They are sitting and discussing a panel, very much like this. There is an interviewer and there are 2 experts. One expert is talking about how viruses affect humans. You can have a pandemic, and we all just lived through a pandemic. So interviewer turns to the second expert and says, "Are you worried about viruses causing a pandemic?" And he says, "No." He says, "What do you mean, no?" To cut a long story short, he makes the point, viruses have been with us humans for hundreds of thousands of years. Our body knows how to fight them. Sometimes some of us don't survive it. A lot of times all of us do. The history of humanity has been the history of fighting off plagues of various sorts, microorganisms of various sorts, and humanity has always won. With a cost, but it has won. He tells us that what he's really worried about are spores, are fungi, which we have never fought a battle with. We have no idea how to fight. And once they take over, they don't consume our bodies, they consume our minds. That is the key thing that he talks about, and everyone is shocked. Now, he points out that we have never fought such a microorganism, fungi, because climatic conditions have not allowed for it. But what if the climate changes? And that's the premise of the entire show, The Last of Us. So I'm here to be that person who scares you. I'm here to tell you that whatever we have seen so far, and I think what Sudeep and Danya have done a great job of laying out the ground for you, has been to tell you of our battles with a certain kind of virus, right? To our battles with a certain kind of effort to clamp down on free speech using law, using technology, in various ways. And we have seen this, and as Sudeep talked about it from the colonial times, what were the impulses driving it then? And as Danya brought it to today's context, what are the impulses driving it now? And I can imagine that when the organizers chose this particular topic, they had 2 or 3 legal measures in mind. One is, of course, the fact check unit, which Danya mentioned, which is likewise the broadcasting bill also, which Danya mentioned, and both of which have been withdrawn. Right? Now, these may be temporary victories, and as Danya was mentioning, they may come back in different forms. But I feel we know what to do. Right? We may succeed or we may fail. But we know what to do. And we know how to push back. We know how to work in this context, this democratic framework that we have. The system is not just dependent on a few of us, it's dependent on all of us, and all of us have a stake in this. What I kind of want to leave you with, and what I want you to think about, is where is the future threat coming from? Where is the future threat to our freedoms, and especially our freedom of speech, coming from? And in the specific context of digital media, sometimes that very technology which enables us to express ourselves might be the one which may eventually clamp us down. And Sudeep has hinted at this, and Dhanya has mentioned at this, and I want to talk a little bit about social media websites which have become the internet for us. I am old enough to have been growing in a context where you manually typed out the names of websites and you checked them out every day and you discovered a website. By the way, you may all be fascinated to know that I used to have a directory of the internet. It used to list out every single website. And I used to read through it to see what are the interesting websites to check out. Of course, it's impossible to come up with a directory now, but it's how the internet used to be. Now it's a completely different place. And that different place is controlled by a few corporations. And these are profit-making corporations. Sudeep has already laid out the context, but I want to reiterate this. These are companies whose business is not to help you express yourself. These are companies whose business is to make profits. And the technology is what they use to make profits. And I want us to focus on the technology. We shouldn't see content and the medium as two separate things. Literally, the term free press, what does it mean? It refers to a certain technology. Of course, it refers to the institutions. But it also refers to the technology without which these institutions could not have become what they have, which is the printing press. Right? And likewise, the internet today is a sort of printing press, which is where we express ourselves, which is where we disseminate our content, whether it is through media or our reels or whatever else it is. But this is not just a printing press. The social media you and I use is not optimized for distribution for our interest. It is optimized to drive engagement. This is a very important thing you have to keep in mind. Engagement is what makes money for the social media companies. You seeing something is just one step to the process of you clicking something and buying something or responding to something which makes money for that social media website. And they've also realized that there is no profit there's no profit to be made in just showing you what you want to see or what you need to see. The real profit and the money comes in showing you what you think you want to see. And this is where the algorithms come into the picture, right? This is where I think we need to really worry about what these algorithms are doing to us. There's a fantastic book by Jaron Lanier. I don't know if any of you have read it. It's called Why I Deleted My Social Media. It played a big role in me deleting some of my social media. So please do read it up if you ever feel like, social media is getting to you. The reason why this is important is because your social media, whether it is Twitter, Instagram, Facebook, LinkedIn, gets its money from making you stay as long as possible on the website and reacting to something. And the place where this is coming from is not from digital media, but from gambling. The one other industry where money is made by making you sit in one place and react for as long as possible is gambling. And this is something which gambling companies, especially casinos in the United States and elsewhere, have mastered it. They know what it is that makes us want to sit there in the hope of a win and keep spending our money. To come back to the example that I started with, they know that the way to our pockets lies through our brains. They know that our brains crave this dopamine hit. When you win something, when you get something, when there's a reaction, when there is something which lights up, some number which goes up, our brain gets a dopamine hit. This is our brain responding to certain stimuli which we normally objectively don't find useful, but someone else finds useful to be able to extract the money from us. This is not some big conspiracy theory that's all out there in public. What we need to do is link this to our understanding of what is the future of media in India, if not the world. If tomorrow more and more journalists get onto YouTube, Instagram, because that is where they find freedom, this is a freedom which comes with a danger. And that danger is that your content is not going to be put there because it is good. Your content is not going to get more views just because it serves a societal need or because it is rigorously researched. Your content will reach people based on how you make them react to it. If there are people who believe that my journalism, for whatever you want to call it, should get as many people angry as possible, as many people upset as possible, the algorithm will prioritize you. Why? Because you are driving the reactions. Then the reactions are monetizable. At some point, good journalism will not prevail over the bad ones, because that is not what the platform is trying to do. The platform is trying to make money, and whatever makes money will flow. There is no individual sitting here and saying, I want bad journalism to prevail. There is nobody writing code saying, I want all the fake news websites of the world to prevail. This is the natural consequence of the way algorithms are being used on these websites. And this is the unfortunate thing that I don't think our policymakers or our lawmakers understand. They are so obsessed with how many views Ravish Kumar is getting or whether Dhruv Rathi is reaching so many millions of people. They don't understand what is the underlying technology that is making it possible. They don't understand that control is being taken away from them. This is sort of what we have to keep in mind. The next challenge, the next real challenge for free speech is not going to be another government with another set of laws, because yes, they will do that. They will try that. They might succeed sometime, they might fail sometime. But the challenge to which today we don't have an answer, today to which we don't even know how to fight that challenge, is having our information systems and more importantly our brains being rewired by how we are using social media. And we know the consequences of this. We know that suicide rates for teenagers are skyrocketing because of exposure to social media. We know that young people are being radicalized because of exposure to social media. We know that people are falling into rabbit holes, into crazy rabbit holes about COVID vaccine and COVID theories because of overexposure to social media. There is no one person sitting and saying, I want to send X or Y into this rabbit hole. This is what is happening as a result of an algorithm that even the makers don't understand why it's having this consequence. This is the challenge before us. You as the young lawyers, or you will be lawyers, you will be called upon to face this task. You cannot use the existing concepts because they were evolved at a time and a place when technology was used in a certain way for a certain purpose, for certain context. The law of defamation as we know it really became meaningful once the printing press took off. And it had to evolve, it had to adjust, it had to address different contexts. But you as young lawyers and policymakers and politicians maybe, hopefully, you will all have to deal with this challenge. How do we rein in these algorithms which are under the control of mega corporations, which are possibly among the most powerful companies the world has ever seen, but whose effects even they don't know what is happening, whose effects are being felt, and whose consequences we're all having to live with. And in the specific context of digital media and freedoms and our freedom of speech, how do we ensure that we preserve all those things which we think are necessary for a democratic society, which is the free exchange of ideas, which is the open atmosphere for debate, without compromising on the fact that our minds are our own and our thoughts are our own. So with that, I'd like to conclude. Thank you once again for inviting me. I hope I have sufficiently scared you because that was my intent. So I'm leaving you with a lot to think. Thank you once again, and I look forward to your questions.
So the organizers have requested us to wind up this session within 15 minutes. So we'll have the Q&A session right away. So I request the volunteers to circulate the microphones to those students who want to raise questions. So try to be brief with respect to your question. Be focused. It's a question-answer session, not a sharing of opinions. So you can be very specific, and you can also identify the panelists to whom you want to specifically address the question. We may have only opportunity for a few questions. Please do raise your hand, and the volunteers will approach you.
A very warm good afternoon to all the respected panelists. My question is particularly to ma'am. Ma'am, we have seen that be it the traditional media or the modern media have YouTube channels reporting, most of them show content which are somewhere or the other back. Let's say if I'm seeing a channel X, it is showing me content which might be in favor of a political party A, and a channel Y showing me same news, but then showing me that aspect of the news which is backing the political party B, which shows us that as we say that press is the fourth pillar of the democracy, that whole statement get false when we see such type of journalism being happening. How can we control this? Moreover, we see that recently CCI approved the news channel being bought by Adani, and we all know, by and large, Adani is again backed by a political party. So how can this be controlled, and what could be an ideal state for journalism where journalists can actually be the fourth pillar of the democracy?
If I understood that, are your ears bursting now? No. Okay. You're asking for an ideal scenario where journalists can work. I don't think that exists anymore. We are in a very polarized media environment also. And I think there is no going back from that. All that we can hope for is that there is more diverse media funding. Like, for example, the big media houses, there is more diverse funding in those media houses, which will help them to have some semblance of independence. As far as digital media is concerned in India, I think they are more or less fine, which is also the reason why the government wants to regulate them, right? The fact is that they are not dependent on, mostly a lot of English media at least are not dependent on government funds or anything. They are run by their readers, subscription, membership, whatever it is. But as a consumer, now, there is no ideal media scenario. The question normally which is asked to me is that what is a ideal consumer scenario? Like, how do we believe news? Because channel A says this, channel B says this. There's no ideal scenario for you also. You have to watch channel A, you have to watch channel B, you have to watch channel C, and then eventually you also choose the path of this is the person to believe, that is not. But I think at the heart of it, you have to follow a media house which tells you what is A saying, what is B saying, and what is C saying in a story. But it also tells you if B has power, if B is the oppressor, if B is above in the hierarchy, and therefore it's not equal to A and C, right? So A, B, C are not equal. I think that's the only thing that as viewers you can look at. There's really no ideal scenario for the media anymore.
Good afternoon. Ma'am, my question is to you. Do you think that there are certain groups of people in the country that are currently in denial of the fact that even major news publishing agencies, both digital and traditional, are fully being controlled or backed by a certain political party? Because multiple people have made the switch over years from one newspaper publication to another due to biased reporting, only to find out that the biased reporting that they were trying to escape has been shifted to the newspaper that they changed to. And do you think that the consequences of this denial will result in future complete control with no hopes whatsoever of coming back by a certain political party?
I couldn't hear most of the question actually. It's not very audible what you guys, maybe you guys can come to the front or something because it's not very audible for us. Or this fan is really loud. But then we'll burn if you switch it off. So, yeah, we'll melt.
Hi ma'am. So my question was, there are people in this country that are currently in denial of the fact that our media systems, our newspapers and our channels are all being in a way controlled by a certain political party. Do you think that this constant denial will also eventually lead, constant denial by the people will lead to a future complete control, complete dictatorship over all media outlets, regardless of how independent those media outlets may try to be?
Yeah, okay, I got your question. So I just want to amend your question a bit. The control over media is not just by political parties, it's also by corporate interests. There are, is there anybody from Tamil Nadu here? Okay, so, ungalukkellam theriyum. For years, you know, Sun TV பார்க்கும்போது Sun TV is DMK, JR TV is AIDMK. It is there in your brain, right? When you watch TV, you exactly know what it is. So, you've expected that for many, many years. In Kerala, if you watch Kairali, you know, okay, this is CPIM. There is no major Congress channel, I think, but there are ones with tilt. So, there are Jai Hind, okay. There are directly funded ones which people are anyway aware of. But the problem really is in the funding which is opaque, which you actually do not know who is putting the funds. It could be companies working at the behest of political parties. I mean, I can think of so many English news websites which are actually funded by, these are small websites only, but these are funded by companies who are in turn told by political parties to pay money. So there's a lot of opaque funding also. I think people have to understand that there is a lot of problem with how media in this country is funded, which is fundamentally why we have such shoddy journalism also, right? And yeah, you cannot be in denial, which is why I spoke about T.M. Krishna's case in the Madras High Court against the digital media rules. He went to court saying that as a consumer, I am most impacted by this. So you're not just impacted by the rules or the framework the government tries to bring in, but you as consumers are also eventually impacted by who funds your media.
Am I audible? This question is directed to Mr. Alok Prasanna. So, what sort of regulation could help us tackle these tech giants that form the primary medium of our expression? Is it even regulation? Do we approach it from a different angle, or how do we tackle these monopolies, considering?
The short answer is I don't know, and nobody has figured it out yet. And when I say nobody, I also mean that even countries with far greater state capacity than India are struggling with it. I believe the previous session we had the gentleman from UK, Professor, I forgot his name, talk about the EU regulations. EU regulations are today relevant for the internet that existed 10, 15 years ago. Imposing intermediary liability, get rid of this, get rid of that. All good, not relevant anymore. I don't think any country has figured it out yet. I don't think they have fully acknowledged the state of the problem yet. One way the solution might be created is in a very different kind of internet, a decentralized internet. I today found out that you can download all of Wikipedia. All of English Wikipedia, you can download. Wikipedia actually encourages you to do it. So if you want to download it on your laptop right now and you have a good connection, you can do it. Can we do that for content in a different way? Can we imagine a different internet which cannot be monopolized in some ways by the big tech giants? Don't believe in AI. AI is another tool, it's another trick being used by big tech companies to extract more money from us. It's not a tool which will help us very much, to be very honest. But this is the challenge that I'm posing, because we need to think along these lines. Yes, governments will try to find ways to throttle digital media. Yes, we will need to fight on that front also. But we need to be prepared for the next battle. It's no use looking back and saying, oh, we wish we had thought of that then. Because this is what is coming our way. And I think it requires a lot more thought. It requires a lot more engagement. It requires a different way of approaching the problem. And that's why I sort of left it at a question. I am not offering a solution. That solution is the next 10 years worth of work. And that's possibly where you will all have to be involved.
We will have maximum 2 more questions, and then we'll be winding up. Yeah.
So good evening to the panel. My question is with respect to age-appropriate content regulation, because children are vulnerable to such contents online, and since harmful content has not been mentioned anywhere or defined anywhere under law, so how do you see it, and is there any regulation with respect to that, because broadcasting bill has been taken down right now, so may I know your view? So this is to the panel.
Can you identify the panelists to whom you are addressing this question?
Sir, it is to Danya ma'am and Lokna.
I'll take a stab at answering that. I think we have to be kind of aware that for the longest time, tech companies have known that their content is harmful to children. And it's not about the definition. Look at the consequences. I mentioned it a couple of things during the course of my talk. The fact that suicide rates have gone up with teens, the fact that mental health of an entire generation of people has been affected. This is not something, we are finding it out once it became public, but tech companies have known this. And we have to hold them accountable for it. Existing legal mechanisms allow for it. there are ways in which, like for instance, the Data Protection Act. Unfortunately, we have an extremely diluted data protection law, which offers no real protection against anything, which is why we are forced to look at EU GDPR and say, please at least follow that so that we don't suffer. But we have to hold them accountable. It's not so much the definition in the law, it is the fact that these are all well known. The consequences are being seen, and the companies know it. But we haven't been able to hold them accountable. That's the problem.
So we'll have the last question coming up. Yeah.
Yes, sir, this is Ravi Vyas from Gujarat. Sir, we know that we are along with the Bharatiya Nyaya Sanhita law from 2020. We have a BNS. Now I'm through. We have a BNS Act 2023. Now, if you see, sir, sedition section is abrogated, and along with that, section 152 is added, which talks about sovereignty and integrity of the India. Reverse of that section, section 197 of that particular act says that if anybody can mislead the information, if anybody can mislead and publishes different information, then he or she can be punishable. So, sir, I want to ask, is there any pros and cons of this particular section as per the media section?
I basically feel that this is one of those cases where the law has been rendered irrelevant by the internet. And when I just say the law, I also mean the legal institutions. You can file all the complaints, FIRs, investigate, take action. Fact is, we don't have a judicial system capable of delivering on time. This is how to think about any criminalization, right? Any person who's committing a crime, let's say consciously, I'm not talking about momentarily committing a crime. Let's say somebody is deliberately sharing misinformation. That person is making a calculation, what are my chances of being caught, multiplied by what is the penalty that I'll get. If my chances of being caught and prosecuted are so low, I won't worry. I don't care. You can put whatever you want in the law. The other problem is we are still sort of, I know they've changed the section numbers, but the concepts in the BNS are still Macaulay era concept, right? That they don't understand how transmission of information has changed. Today, we are capable of basically reaching the whole world in less than a second. What legal framework acknowledges and accounts for that? 20 years ago, we couldn't have imagined this. So I don't see that, at least criminal law or law which is supposed to criminalize and punish certain, I don't think they will provide for these solutions because we don't have the institutions, we don't have the concepts which can adequately address it. So I won't rely on it very much.
So friends, we are reaching the end of this thought-provoking session. In fact, we had three dynamic panelists. In fact, Dr. Sudeep started off by highlighting the role played by the media, particularly the print media, in the Indian national freedom movement, and how public opinion was being created in favor of the national independence movement, and the role played by the various journalists in that process. And he also highlighted the fact that, the view that digital media in contemporary times is not regulated or is an unregulated space is totally a myth, and it's totally something that is not true. And then moving on to Ms. Dhanya Rajendran. Dhanya Rajendran was highlighting the various frameworks through which, the digital media is, particularly journalistic freedom in the digital media, is being suppressed in the contemporary times. And Mr. Alok Prasanna was highlighting a challenge that lies ahead, where algorithms that are under the control of big corporations may block access of media outlets to diversity of viewers, and also block the access of viewers to diversity of views. Well, it was really a thought-provoking section, in fact. And to end up this session, I would like to conclude by observing that the striking a balance between the protecting the freedom of speech and expression, which of course is very much essential for a democratic society like ours, and enforcing the necessary legal boundaries. Of course, legal boundaries are required, and journalists also should be accountable like the people in power. So this balance of this challenge of striking this balance between protecting freedom of expression and enforcing the necessary legal boundaries requires thoughtful consideration of ethical principles as well as legal principles. And it also involves creating frameworks. What type of frameworks do you require? You require frameworks that would promote responsible journalism, particularly in the digital media. And that framework should also ensure that, particularly it should ensure that this regulation does not turn out to be an instrument to suppress this freedom of expression, and also it should not amount to a mechanism for controlling the narrative. That is very important. And so the challenge, what is the challenge that lies before us? In fact, the challenge that lies before us is to ensure that, that journalistic freedoms are protected while ensuring that law evolves to meet the demands of the changing digital media landscape, because it is a fast changing landscape. So the law needs to keep up with that challenge also. As Mr. Alok said, new challenges are emerging day by day, maybe every minute. So you need to address that also. And achieving this balance is something that is really difficult, but that would require ongoing dialogue. It should be, this balance has to be struck by dialogue, which should be an ongoing dialogue. There should be collaboration between stakeholders, and there should be a shared commitment on the part of everyone. Shared commitment towards both press freedoms, or the freedom of the media, and also responsible media practices. I am sure that this conversation that has happened today has sparked new ideas and reflections, and we will find ways to address these challenges, and I hope it has sparked new ideas in your minds also. You can continue thinking over these the ideas that they have shared, maybe develop it into paper, develop it into your own independent views. And I thank the organizers for creating this kind of a platform, for providing me this opportunity to moderate. On behalf of the panelists, I thank the organizers for inviting them and providing a platform for this free and frank sharing of opinions. And let's see how we move forward in addressing these challenges. Thank you.
Thank you to all our esteemed panelists for sharing such diverse and thoughtful perspectives on the challenge of media regulation and journalistic freedom. We truly appreciate the depth of this discussion.
As we approach the end of this session, I would like to request Dr. Jacob Joseph, our moderator, to present the panelists with mementos as a token of our appreciation.
Now, I request our beloved alumni, Advocate Sanil KM, to present a memento to Jacob Joseph. Thank you, sir. Now, I request our beloved alumni, Advocate Sanil KM, to present a memento to Dr. Jacob Joseph. Thank you, sir.
This brings us to the end of this panel discussion. We will now be having a networking break accompanied with tea and snacks. All the participants are requested to move downstairs, as into the ground floor of
We are honored to welcome you to the next panel discussion on evolving dynamics of performing rights and copyright societies, legal challenges and opportunities in the media and entertainment industry. Joining us are three distinguished speakers, Advocate Devyani Nath, Dr. G.R. Raghavendra and Mr. Sanjay Tandon. Moderating the session is Dr. Adara P.S., who will expertly guide us through today's conversation. Our first speaker, Dr. G.R. Raghavendra, is a senior consultant at the Department for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, with an impressive career as a civil servant. He has been a key contributor to legal reforms, including the National Mission for Justice Delivery and initiatives to improve contract enforcement. With a PhD in performing rights and extensive involvement in IP policy and free trade agreements, he is a prominent voice in copyright law. We welcome you, sir. Our second speaker, Mr. Sanjay Tandon, is a renowned figure in the Indian music industry with over 34 years of experience. As a founder and CEO of the Indian Singers and Musicians Rights Association and the Singers Association of India, he has played a pioneering role in collective copyright management and has been instrumental in historic agreements uniting music companies and artists. Mr. Tandon is also a recipient of numerous prestigious awards for his contribution to the industry. We welcome you, sir. Our third speaker, Advocate Devyani Nath, is a managing associate at Fidesz Law Chambers. Her primary area of practice is IP litigation and is also a strategic advisor on IP transactions. She has advised and represented various clients in the edtech, media and entertainment, textile, electronic, IT and hospitality industries. As an IP lawyer in the media industry, she has advised clients such as brands and businesses on copyright licenses and the nuances of copyright societies. Thank you for joining us, ma'am. We welcome you. Lastly, our moderator, Dr. Adara P.S., is a leading academic in intellectual property law with a focus on IP, health and bioethics. She holds a PhD from the University of Kerala and is a faculty in charge of the Center for Intellectual Property Rights here at Nuals. Her expertise in organizing various academic programs on IPR makes her ideally suited to steer today's discussion. Please join me in extending a warm welcome to our esteemed panelists and moderator as we commence this insightful conversation.
Good evening and welcome to this session. We are very happy to have this very illustrious panel with us to talk about evolving area of media and entertainment law. So to give a bit of context to this particular session, I'd just like to talk about how the administration and licensing of rights of individual participants of the entertainment industry usually works. So, as you know, there are economic rights as well as moral rights within copyright, and most of the discussion happens on the front of the economic rights. But moral rights, which is essentially of a French origin, are also very, very important. And what it means, its genesis is from Berne Convention and based on philosophy much earlier. And it speaks primarily about paternity right as well as right of integrity, right against wrongful attribution, as well as right to rightful attribution and against mutilation. So moral rights are basically what are mostly addressed through copyright societies as well as unions, where individual composers, lyricists, producers, music composers, as well as even companies are represented. And today our discussion is primarily focused on that. If you look at copyright law, we understand that technology has a lot to deal with it. From a time when a performer was considered as nothing but an instrument of the director, we have come a long way, and a performer's rights stand independently of its own today. So, without taking more time from this very deserving panel here, I'd like to first introduce Raghvendra sir to give his opinion. Sir, would you like to sit? So, over to sir.
Yeah, thank you. Vande Mataram. Good afternoon to all of you. I would like to thank Nandini and the NLU Kochi for inviting me here and to share my thoughts. Many students may be aware about what are performing rights, and few may not be aware. So when you listen to Radio Mirchi or any FM radio, that is a performance is happening. When you go to restaurant, performance of the music happening. When you go to a restaurant having a dinner or a lunch, background music is happening. That is also public performance. And when you are traveling in the airplane, you choose to listen to the songs airplane is playing. That is also communication to the public. Public performance is happening. So the economic rights she was talking about, the public performance, communication to the public is one of the rights, the economic rights of the authors. So it is the author's lyrics are performed there. It is accompanied by another work, not only the literary work of the author, and also the musical works by musician who is composing music. So song is a combination of literary work, author. So Gulzar has written a song. A.R. Rahman has composed music. Both are your listening. Okay. But there are two models. If you're listening, radio FM platform gets money from advertisements there. So you don't need to pay. And if you go to OTT and Spotify or any other app you have downloaded, YouTube, there are two models. One is a subscription. Why should I subscribe? Once in a blue moon I listen to songs. So that is allowed. That comes with the ad. You want ad free, then I have to go for the subscription. Then the two-way they are earning the platform on our going. So it is also communication to the public happening. So authors have to get royalties for that. This is a big issue. It all started in 1840 when young creators like Ernst Boje is an author, lyricist, and Paul Hernian and Victor Parijat, two composers who compose music for his songs, lyrics, went to one hotel where live music is being played. Those days it became very popular. It's an innovation by hotel Ambassador Hotel. No, it's not exactly hotel. The kind of outside chairs are played and music played and all that. To the surprise of these guys, the lyric written by Ernst Boje, music composed by Hernian and Parijat, Victor Parijat, commercially played there. Then these people say that you you have to pay, you're not, without permission you are paying these songs, commercializing. It's a very commercial. People are coming, many are coming for music, not for drinks. These drinks, beer, whiskey, wine available elsewhere in hotels. Your hotel has become popular because of my song. Not without permission of me, give us royalty. They were thrown out. They went to a young lawyer. The first district court, first music royalty judgment came, no, you have to take a license for any commercialization, they have a right. They have to take a permission. So then everyone came to know, and there is a need for a copyright collecting society. Because each and everyone can't run around hotels. Not only in the Paris, maybe other cities in the France, or other restaurants in London, UK, Germany, other European countries. So SACID came into existence, the first copyright collecting society for performing right in the history in 1840s. Then that became virus, and you have so many, the English PRS came, and in America, various other, and India, the IPRS came long back in 1969. Yeah, 1969 it came. But unfortunately, the Berne Convention, which took birth in 1886, expressly does not mention about collecting society or a copyright society. So, but the provisions, the Article 10, Article 11, Article 11 bis. Article 11 bis goes to the extent that if rights have been transferred to the producer and it is exploited separately, they introduced called single equitable remuneration right. It began in the 11th Berne Convention first time. But these things are happening only 1994 copyright amendments. The concept of copyrights, collecting copyright society registration for the business of granting licenses and collecting royalties with the tariff scheme and distribution scheme, this was done. When this was done, and same time, Naushad, a famous music composer, he along with all the music composers and lyricists entered an agreement with the sound recording companies. Why songs are produced and included in films? Why they signed a contract with them? Because it all concept like film producer, master recorder. So those rights are sold by film producer in advance to music company. And music company will have two rights then, two music rights. One is sound recording right, the master record is they have done. They will not share the royalties there, even 100% collected royalties. The royalty is not made. So that they collect, along with the performing right, performing of these authors, composers, authors' words, lyrics, and the music. So this way, the performing right, here he will share 50%. That is the international concept. 50-50 they share. Despite this percentage was agreed to in an agreement of Naushad with the lyricists and music composers, music companies, some problem came. For some time, the moment it was done, Sanjay Tandon will tell that he was the CEO of IPRS those times. And even during his times and after he left, the things worsened that 50% royalties were not getting in the pockets of many author composers. There is a famous story of Kemchand Mehta, who died with heart attack at 42-year age, famous music composer. His song Aayega, Aane Wala Aayega. Even people don't know Hindi must have heard this song in a deep south. As a kid heard this song when I was from Andhra, Kannadiga from Andhra. But the song still. But you don't remember who sang this, who is on picturized on which actress or which actor she is imagining, no idea. The song became famous. This guy died of heart attack and wife was apparently on the street. So he sent a check. Somebody told him that she is on the street, and he sent a check, and the family, got some life. That must be small amount. But like this, even Masroor Sultan Puri died, and the IPRS check went to the author that helped his family to survive. And when the famous music director Ravi died, he had no money. People like Sanjay Tandon, Javed Akhtar, Ladin Pandit, these guys are rushed to and claim the body. Hospital will not see whether it is celebrity, means all done karenge. Ravi is such a music director, Chaudhary ke Chandko. Your boyfriend or you must have sung this song at 10 times, or you must have listened to song many times. And Amraj songs, beautiful songs of Amraj. And Neele Gagan Ke Tale and all. He is a music composer, great music composer. And he dies in the hospital, no money. So this is very, very important. And we introduced in the law because 1977 there is a judgment, Eastern Motion Pictures. Eastern Motion Pictures Producer Association won the case against IPRS, 1977. Judgment written by Justice Jaswant Singh says, as per the section 17, even though subsection 1 says first owner of the copyright is the author, that is the songwriter and music composer, but B and C there with consent or with agreement or without agreement, when you assign the rights, the producer becomes the owner and you don't get any royalties. That's what the judgment said. You have no right for IPRS to collect the royalties when public performance is happening, even though registered copyrights. Only Krishna Iyer, with the famous Justice Krishna Iyer, who is a Keralite, and he wrote in the Arbiter Dicta saying that the penumbral area of policy making, government forgot the rights of these people, not only are the composers, even performers, he said. So that inspired us to amend the laws in 2012, recognize the 50% rights of not only are the composer, also the performer. This we have done. So first time in the world, no country has given the business sharing percentages in the law. And everybody was surprised how India can do. But despite India is not a member of a Rome Convention, Article 2, secondary rights, it explains, if a market is not functioning, the law can introduce the royalty percentage to be shared by the right owners. So that's what India is the only country utilize Article 12 of the Rome Convention. India is not a member of Rome Convention. Please remember. So it only harmonized the Rome Convention with Indian law in 1994, introduced sound recording right, introduced the performer right, and copyright society and all that. And of course, broadcasting right also was introduced at the time. So many reforms were made, but it was not working. Now, but this helped the society to get revival and collection. If you see the Confederation of Performing Rights Societies, the CSAC, which has more than 126 countries, with some countries have multiple copyright societies, like Thailand has 10 societies. US has 4 top societies for performing rights. India has only one Indian Performing Rights Society, because we know even IPRS functioning is still doubtful. Because people are not giving royalties, including a government organization like Prasar Bharati, All India Radio and Doordarshan. They also talk like that. When I go to a shopper's stop in a mall, buy a shirt, I pay only to the shirt $17.99. $1,799. I don't pay to the tailor. I don't pay to the weaver. I don't pay to the cotton grower of the cotton shirt they are talking about. So why should I pay so many royalties? Arey bhaiya, music has performing right, lyricist right, composer right, performing right, sound recording right, master copy, singers right, Isra, Sajid Tandal is also singer, and there is a performer right. So 3 licenses you have to pay. So everyone talks this language, and implementation, still there is a problem in that. Despite copyright societies are there for all the rights. So, to avoid this only, recently Honorable Minister Sri Piyush Goyal suggested that the industry should come together, have a single window. So instead of taking 3 separate licenses and making the 3 payments, you take 1 license, make 1 payment, and these guys will distribute. So this is the method maybe going to come, and I rest now. You charge to my colleagues, and when you come back with the questions, I'll go on. Thank you.
Thank you for having me. Yes. Thank you, Dr. Raghavendra. It was a really insightful conversation. And as he rightly said, currently we have so many different copyright societies for different categories of work. So if I want to take a license for sound recording, I need to go to RFPL or PPL or NOVEX. But at the same time, I will also have to take a license for my TRS because the underlying work is also getting exploited. So there is a little bit of confusion that is happening. But the one important question that we always have is, PPL NOVEX are not registered copyright societies, but the work that they're doing is exactly what copyright societies do. There is Madras High Court which said that NOVEX cannot collect royalties, but Delhi High Court recognizes their rights. So even though we have a concept of copyright societies, but it's not been streamlined to that effect till now. And it has become difficult. So I had a situation, a very interesting case that came to me, where the client had taken a license from PPL. To what extent will the person who wants to utilize the song research and figure out whom to take the license from? Because there are so many organizations at the moment. And it just does not end there. It's one thing is performing the song in a DJ event or in a hotel or in a private event. But we also are dealing with digital performances, for which we have another concept of mechanical licensing coming into place. And there are societies which are collecting mechanical licensing. So all these songs that are played on Spotify and YouTube and other Apple Music and all, they collect mechanical licenses, they give those royalties to the underlying performers. So there needs to be a streamlining of how these copyright societies are going to work. Another interesting debate that is happening nowadays is, do we need license for performing songs in weddings? And the most recent judgment of the Bombay High Court Goa bench, where it quashed one of the circulars that was issued by the Ministry of Home Affairs in Goa, which said that, in my opinion, it gave excessive powers to the police to interfere when a notice is displayed in wedding and related functions in a hotel. But the question is, at the end of the day, if a music is being exploited commercially, in a wedding function, it's in a way he's exploiting the music commercially. So how are we using the exception in this case? And the judgment very nicely brings in the question. So if we read the provision would say bona fide religious ceremony or weddings and related functions. What is bona fide? How do we define what bona fide is? And the judgment, the Bombay High Court judgment and a similar judgment had been pronounced by Punjab and Haryana High Court. They had said that it's going to depend case to case. Who decides case to case? Because notices will always be sent by BPL or NOVEX or RMPL saying that you should have taken a license, paid the relevant royalties. But it's very difficult to decide. So it's currently agreeing, IPR has a provision where if I want to play a song in a wedding, I can fill in a license, which is a no royalty license. I can tell them that I will be playing this song, and accordingly I have that safeguard that I don't need to pay, and I have a certificate which says that this is being used for weddings. But what if I am actually have a company event that is happening in a hotel, and it's kind of like an annual day that is happening in a hotel, and there are company employees who are performing on songs, and I am paying certain money to the hotel for that event to be organized. But that song performance is actually a private event that is happening, and as we know, there is an exception for royalty payment in a private event because there is no commercialization that is happening. But again, the question is, I am paying money to the hotel to conduct that event. So there is commercial exploitation that is happening of the song. So we need streamlining between collection of royalties and the various exceptions that we currently have under Section 52 of the Copyright Act. And yes, very different organizations, as Dr. Alumni said, it's important that we bring it under that one window, and that's how it can go forward.
The legal perspective of it, Devyanji has given the standing problems of it, highlighted and sort of flagged off this. I started IRRO, which is the Reprographic Rights Society. I started ISAMRA, which is for the singers and musicians. So I am the creator of it all. So I can, without a fuss, taking a blame on that, because copyright, as you know, I'm not going to give you a lecture on copyright because all of you are students and you have learnt about it from your professors. I'm no professor. So it's a bundle of rights. And when it is a bundle of rights, there are different stakeholders to it. And different stakeholders, therefore, are given the freedom by the Copyright Act to collect their royalties. Ye to Act ne bol diya. Act has said this very so easily, you know. Oh, Mr. Composer Rajan to go and collect his royalties, and then you saying, A.R. Rahman, you collect your royalties, and then you are saying to a singer like P. Susila or S.P. Balasubramaniam, you go and collect your royalties. Then you're telling all the music labels, Manorama and everybody to go and collect their royalties. My God, this is going to create a havoc. So, if there is a song played, song is music. And we all need to understand that music is something to be enjoyed, not to be stressed out. Music removes the stress, should not bring in stress. So, the Act itself gave the answer. It created a chapter, chapter 6, and it gave the answer that, oh yes, there can be collective administrative societies. Because, please understand, the societies, that's what the subject is. The collecting societies that are there are rather doing a very social service job. They are linking the end consumer to the end artist, to the end IP owner. Because just imagine, you want to play 4 songs here. The 4 songs will have 4 different writers, 4 different composers, 4 different music label or sound recording owners, 4 different singers. To play these 4 songs, you have to go to 16 people. Do you think everybody is available and everybody is going to pick up your phone? No. Then what happens? Your program gets delayed. Okay, you get all 16 of them. The next question is, what are you going to negotiate? What are you going to negotiate with, say, Lata Mangeshkar? She might say, you give me 10 lakh rupees. Or you can just negotiate with a person like me and I'll say, okay, give me 1 rupee but play my song. So there is no uniform tariff structure. There is nothing. So the end user would rather, he wants to be honest. He wants to be an honest citizen, law-abiding citizen of the country. But all these hassles make him illegal. So that is the reason why. And similarly is the process for the artists. You think Asha Bhosle, Lata Mangeshkar, A.R. Rahman are going to go in every restaurant of this street or his street where he is staying and then forget about the city of Madras and then the whole of India and then the whole of the world?
Even legendary singer from Malayalam Jesdas.
Yes, Yesudasji. So you think he's going to go into all these restaurants and say, oh, hello, give me my royalty because you're playing my music? No, that's not possible. And therefore, this concept of collective administration came, where one society should be there in one class of work and should give that license. So it's a one window. So first of all, the conception has to change. There is already a one window in existence, except that there are 4 windows in this house. Now we are talking of a door, not a window. So the 4 windows are very clear. You need to take, as per law, the composer, when you play a song, the song is a mixture of the person who has composed the tune, the person who has written the lyrics, and they have together formed a society called IPRS. So that IPRS is giving you the license and taking the royalties for composers and songwriters. Composers and songwriters are creators. They create music. Singers and musicians are the ones who perform that music. They give expressions to that. And therefore, in 1994, for the first time, the performers' rights were recognized in our law. Of course, it was recognized in a very vague fashion. Give it by the one and take it by the other. So it made real no sense. And therefore, I together with Lata Mangeshkar ji, we fought with Sonu Nigam and Alka Yagnik joining in. We all fought this, struggled to get this right recognized by the law. And therefore, ultimately in 2012, the performers' rights were streamlined. The law with respect to performers' rights was streamlined. It was actually recognized as an economic right. It was actually recognized as a moral right, and everything was done. It was streamlined thoroughly, and Mr. Raghavendra played a great part in that. I thank you and I respect you for that. And so what happened then? We came into being ISRA, which was the Indian Singers' Rights Association, and now from 1st of January we have come from ISRA to ISAMRA because we have now included the musicians also. So now again you see there are 2 windows. One window is to take the royal license of the composers and songwriters. One is the artists, which is the singers and the musicians who play the music. So this is there. The third window is that of the music labels, who are the owners of the sound recording, because they are also given sound recording holders or the owners, so as to speak, of the IP property, which is called a song. So song is jointly owned by all these people. And of course, if you talk about films, then another the film producer comes into play for the film part of it. So everybody is looking after their own this thing. And copyright societies are left to their own, to make their own tariffs, the rate cards, and they have own tariffs. But yes, of course, now, as Raghavendra was mentioning, our Central Minister of Commerce and Industry, Shri Piyush Goyal ji, has now embarked upon and has made a committee to go into this aspect. Why don't all of them come together and give one window to everyone? So we are working on it. Anup Jalota ji is the chairman. I am the convener of that committee. So it's working very well. So that is there, and usually I like to take questions whenever I'm available because it's very difficult to hold myself to myself because I'm traveling a lot. But wherever I go, I first love to answer questions because everybody has a lot of questions with regards to copyright music licensing. So I'm open to it. Other than that, yes, copyright societies give a lot of value to everyone. So they're not supposed to be treated as anything of a villainish style. They're not villains, they are heroes. They're actually doing a great social service. Of course, they have to do it with a lot of authority. So therefore, they're considered to be arm-twisting, etc. But it is not done. And one thing before I sign off is that, first of all, we all as Indians, need to change our mindset. All Indians believe that playing music is my birthright. No problem. Because we are born with music. The first cry of the child is music to the mother's ears. And today we cannot walk 100 meters and not hear music being played. Music is very essential for humans. But the Indian mentality, the mindset is very bad. It says, music is my birthright, but I won't pay for it. You're ready to pay for this bottle. Why don't we agitate to this guy that the water is coming free from somewhere in the mountains? Being respected And what is the respect? You give a shawl, you give the shrifal, that is the coconut, and then you say thank you. You are very great. What lovely music you make. Oh, love you. I am your fan. Boss, usse unka ghar nahi chalta hai. Kitchen doesn't run with this thing, with the nariyal and that shawl. Shawl, you should wear it yourself, take it home. The nariyal, break it on your head and eat it. Give that poor man money. We all here who are there, the two big lawyers, you're going to make money, you'll have your own retirement programs, etc. But the artist doesn't. Because the artist only knows his art. The artist only knows how to create. Let him free to create. We should make it available. We should understand that we should not use illegal music. We all should change this thing. Even the lawyers, I'm saying, the lawyers should not support anything which is, it's of course your business. I'm a lawyer too. So it's our business, no problem. But when it comes to art, even have a heart. Because one English word can be interpreted both ways, we know it. That's what we are learning in law. But what is correct, what is happening in the world should be followed. If it is followed, in India also, we will have copyright respected. So all I tell everyone is respect copyright, encourage creativity. Thank you so much.
So, Raghavendra sir would like to clarify on a particular point which is raised during the panel discussion. Okay?
Yeah, the question came about the exploitation of songs during the marriage ceremonies. Why that should be given exception. And I request so many audiences sitting here, please raise hands when a marriage ceremony, wedding ceremony you attended, you bought a ticket like you go to a film, you buy a ticket and go. How many of you bought a ticket to attend your sister's marriage, a friend's marriage? Please raise your hands. Is it a commercial event, marriage? But it is a bona fide religious ceremony. What is a bona fide religious? When it starts, when engagement happens, it's a religious ceremony. Boy and girl, both families come, religiously mantras recited. North India it is called roka or engagement. After engagement, marriage happens. There is a barat coming, dancing and singing, music played and that. It is also not a commercial exploitation of the song. If you read Ajurveda, I wrote an article for the CUSAT National Conference. In Ajurveda himself there, marriage ceremony, when Barat comes, music is played, relatives to instill a positive, express happiness, music is played. After that they come and sit, mantras and Mangala Sutram has to be taught. Saptapadi, which is included in Hindu Marriage Act. Hindu Marriage Act says, even though you have the registered marriage, unless you have a Saptapadi, marriage is a void. Because if you are getting married, special marriage act, that's a different. If Saptapadi is not religious, that is a bona fide ceremony. What happened during Saptapadi and Mangal Sutra Dharan? Music is played. Okay? And then, before Mangal Sutra happens, there is a Haldi ceremony. Both sides apply Haldi, play songs, happy. Again, it is from the Vedic times it is coming. It is written there. And there is a special music ceremony. Okay? That is also not. Tell me how this thing you attend, 3-day marriage normally in South India, North India, maybe less days. You buy tickets for everything and go, everything is commercial. No. So why is the exception? While supporting with my full heart the rights of authors, composers, or the sound recording companies, there is an exception. Why this exception originates from the Berne Convention? I told you Berne Convention harmonized the laws of economic countries like UK, the economic copyright, and author-based civil law countries like France and Germany. So these people are differently treated. There was a need for harmonization. Berne Convention happened. Berne Convention was amended like Indian copyright law amended. In the 1948, Brussels revision. Many countries, which countries, India only supported the Nordic countries. The Norway, Sweden, Finland, how these people came, that when we play music in the churches, our marriage happening in the church, song is played, these guys come asking for the license. So please give us exception for these religious ceremonies and marriage ceremonies. Then it was decided it is a minor reservation over the right. It is exception, it is simple exception. And the de minimis exception, they call it in the Berne Convention. There is no need to write in the main Berne Convention introducing an article. It is an exception to Article 10, communication to the public empowerment of the rights given to the Article 10, 11, 12 and base. It is understood. It is a deemed exception. This is de minimis exception. Minor reservation. Main committee, announce you go and do it, no problem. This happened before three-step test came. Three-step test came after 19 years. 1946 this, 1967 in the Stockholm, where when India asked we want exception for the reproduction for education thing, okay, you will get exception, but with conditions, only in special cases, which does not conflict with the commercial exploitation of the work, which does not against the prejudice of the author's right and all the three-step test. It passes, then only game. Then we said when introducing this, 1994, it came in 1994, because people were taking police to marriage happening. The guy is, so many girls are here. How marriage happened? Father takes band. You are paying it to the marriage hall. So why don't you pay me? Because they are giving services. For me, marriage is not a commercial exploitation. So the then minister said, done. The question came, what is bona fide religious seminar? I gave you all the examples. Then no thing happens. But finally I argued what Sanjay was saying and what she was saying. Other day what Shah Rukh Khan said, मैं अभी बूढ़ा हो गया हूँ. My age is almost gone. He is reaching 60, I'm 61. एक साथ छोड़ा है. And he said this is not the age to go and dance in the marriages. So he is not a singer. Then music is played. What is the rate of his dance with Priyanka Chopra and Katrina Kaif in the marriage? You know that? 3 to 4 crores. So why should a license banta hai na tab? There are celebrity DJs. They take not less than 5 lakhs, 6 lakhs separately. So that is, they are making commercial use of this. No? So that's why the Nordic countries made laws. When they introduced these laws to the national legislation, including Germany, that spread like a virus, this exception, religious and these things, all the European countries. They said when performance happening as a paid performance, not the band barrage wala paid performance, because that is the exception. So, and a celebrity singer coming, DJ coming, a VJ coming, so tab to license banta hai. But unfortunately my law doesn't clarify that. So that is the tussle between the hoteliers and right owners and common people like us. So when in future law amends, I'm one of the strong supporters that any paid performance happening except the band, marriage ka barat wala band. So royalty banta hai. That's the clarity I wanted to give. Hopefully वो आएगा. आना भी चाहिए. And we can leave it to questions.
So, any questions? We have maybe time for 2 or 3 questions. Yes.
My question is to Sanjay sir. So when you talk about IPRS, the membership sometimes also extends to the music publishers who are sometimes also a part of another copyright society of PPL. So how does this overlap impact the rights of the composers and the lyricists?
Well, it's very simple. All of us are entitled to be multitasking, aren't we? We all multitask. And the more we multitask, the more smarter are we considered in the world. In this particular case, when the music is made, the composer does his job of composing the tune, the writer does his job of writing the lyrics. But they are artists, they do not know how to do business. So therefore they look for a partner to do that business. And in the music world, this partner is known as a music publisher. So what happens, like take for example a book. We all know about the book. Book is very clear. So you pick up any book, there is an author of that book, then you will find a publisher of that book, and then you will find a printer of that book. Am I right? Three things. Same thing is in music. So what happens? There is an author, which is the composer and the writer, then there is a publisher, and then there is a printer. The publisher is the publisher of music. That one is publisher of a book, this fellow is a publisher of the music. All these three get put together, then go to a printer, that please print this book. So they say, please print this music. So the printer in this case is the music label. They print it by using the master, which is called the sound recording under our law, under section 14(1)(e). So these are the three aspects, and therefore in IPRS you have 50% going to the composer and writer, that is 25-25 to the artist lobby, and 50% going to the business lobby. So they share it equally. So in that capacity, whoever is the publisher is capable to join IPRS. And whoever is printing it, the master, is eligible to become member of PPL, RNPL, or whatever those, NOVEX, or whatever the words. So they are wearing separate hats. That's the only thing. In India, so if you take the international scene, there are separate companies. And even in India, you see, there are separate companies also. So there is Saregama Music Publishing Company. There is Universal Publishing. So they are members of IPRS in their publishing hat. And in their sound recording hat, they are the members of PPL. So that's how it is. So there's no, that is very clear. I hope I've cleared it.
Thank you.
Thank you.
Basically two rights. They are getting sound recording rights licensor from PPL, performing right licensor from IPRS. That is the simple.
Namaste, sir. Sir, I have a question regarding Bern Convention. So, sir, as far as joint ownership concerned, how much the term of that particular thing? How much term of a joint ownership? How the term is counted? Like authorship, there is a 50 years term. But as far as joint ownership concerned, how the term is calculated, sir? Another question. What is the anonymous and pseudonymic work? I heard of this thing in the, I think, one convention. So I didn't understand what is actually that work.
Work of joint authorship is mentioned in section 2 Y of the Copyright Act. It says two or more persons. Persons means natural persons. Okay. Writing a work. Either jointly writing an article or writing a chapter in the book or a book itself. So, I am 61-year-old. She must be in 30s. We are writing a book or article together. It's a joint authorship. Because I am senior, I got more, but 60% I'll get, she will get 40%. It's not like that. If he is a publisher, is publishing royalties, he has given 1 crore signing amount. Okay, we will share 50-50, simple. Okay, but what she does is the old man is sitting, she will rush and sign the agreement. I have not signed. It's void. Because in a joint authorship, both have to sign the contract. And tomorrow you come here, translate in the Gujarati, she in the Malayalam, she in the Bengali. Separate, both have to sign and give translation right. And she wants to make a picture. Both picture adaptation rights also, derivative rights also, we both have to sign and transfer. Everywhere equal right. There is no 50% royalties or something like that. We will share money 50%, but one signature, both have to sign. Tomorrow she may authorize me, he will sign on behalf. Because she is busy, has gone with her family or somewhere, and we have to sign, but later she has to confirm us this thing. So this is there. And other question you asked about pseudonymous, anonymous. Pseudonymous, yeah. Anonymous means you have written a book, but you don't want to mention your name there. So then that is anonymous. No one knows in the world who has written that book. Okay. Then when author is not known, how will you get life of the author plus 60 years? You will not get that time. Because you don't want to give your name. So you will get only 60 years. Okay. But as and when you announce the name, it is written by me with the proof, then you get the term extended for life of the author plus 60 years. Then comes pseudonymous. But you write with some other name, pen name. So then you get full term because you are person only. Everyone knows that you have written, your publisher knows you have written, but your surname, like the Guljar, the actual name is something. I don't remember, you must be known. Guljar Saab's complete name. Some Singh or some Purna Singh something is there. Write to the Guljar. Like this. And you will get life of the author plus 60 years. That is.
Good evening, sir. Myself, Seema Lakshmi. I'm a research scholar from SAT. Sir, my question is to Raghavendra, sir. Sir, there was this recent study about this sharing of royalties by Spotify. Spotify was clearly chosen. And the study showed that, say for example, if 100 rupees is the amount that Spotify has received as part of the streaming of a song, the final amount that the lyricist and the composer equally gets is approximately around 8 rupees or 8.75 rupees. So it's almost 8% of whatever royalties that is being shared, that they receive. When I talked to Sheetal Raisingani from IPRS, ma'am has said that whatever amount that they reveal is what they can only believe. There is no true transparent system to identify the transactions that is really happening. So when I asked them if they really only rely on the amount that they specify, that is Spotify for example, specify, they said yes, there is no other way to find it out. And also, when we look into the IMI reports, IFPA, all these reports, current reports, we can see the number of stakeholders in between creation and distribution has increased humongously. From stage 1 to stage 10 or 100, I don't know, the number of stakeholders has increased a lot, that the actual amount, the royalty that a hard worker, that the creator should get, is getting much below than it is expected, that is the 50%. So do you think the law needs to address this in this vagueness, ambiguity? Oh, it's not ambiguity, we know what is happening. But then is it time to address this stakeholder issue and this lack of transparency? Even though 2012 amendment did have the aim itself was to clear this clarity, but then it's still not happening.
No, this is a liberalized economy. In the market, it is called a free market in economics. In the market, in a free market, the intervention of government should be minimal. Only regulate the market, but not fix the price. Only fixing the price happens in a compulsory license. if somebody makes a request that we have failed to take a voluntary license, please give me a compulsory license, then the court may decide. Advanced statutory license is to help the industry to go, only that extent. It's a temporary legal tool. It can be taken out anytime. Then coming to this kind of situation, government can't interfere and fixing the rates. One accusation came when we were saying that 50% share in royalties, equally share we have written. Everyone started saying how government can enter the market and fix the percentage of rates. Then he said international law allows. Rome Convention is allowing that. Clearly written. All the member countries sat and negotiated and made the law. And the Vienna Convention of Law of Treaty 1967 allows the countries to introduce that law in the national legislation. That's what we have done. But how much Spotify contract is signed by IPRS? But ISAMRA has a tariff scheme. They will announce that tariff. They will say for digital rate this much, this much, this much. That is that. They will get royalties as per that. They will advertisement revenues. If you get a free access, that kind of subscription revenue, she doesn't want to see advertisement. Okay. And my relative's boy, he must be about 7-month boy. To make him entertain, they put a song. The moment ad comes, he gets start crying. So they are forced to take a subscription. So like this. So it is the market. So they have a tariff scheme, and then they will not take down. They will say, you can't display this. They will force them to take. But if the individual user generating content, he has upload, then they will force. But he will not. We will not give the same right the copyright societies, the PPL, IPRS, ISAMRA getting, or even Novax are getting. He will be speech to accept to only 8%. 10%. Poor guy will say that I am becoming famous and I have the capacity to create more videos like this by Karlunga. For me, more likes, more subscriptions, more popularity, but more than earning money. There he will adjust. But obviously, copyright law is not going to address this. Tomorrow some regulation comes, then also market economy cannot be managed by the regulator. You can't fix the rate you will get for this much only to Spotify or YouTube or something like that. This is not possible. And it is against the free market economy, and even WTO will object to that. If India does this, immediately EU say USA complaint आ जाएगी, then India will be asked to take that step back.
So due to paucity of time, I think we can have one last question. Yes, one last question. Compromise among you guys. Okay. And let there be 2 questions. Quickly though, okay? Because yeah, so they are classmates. They should have some kind of a compromise.
Yes, okay, sir. So, very good evening. My name is Anirudh. So, Indian Copyright Act grants exclusive rights to producers of creative music, musical works to reproduce, distribute, perform, and convey their work to the public. So, my doubt is, since there was an out-of-court settlement that happened with regards to Ilayaraja, with regards to the Manjumal Boys case, which took place in the Madras High Court, there isn't a set position yet as to who is the definitive owner of the particular copyright of that particular music. Whether it is the producer of that movie, or does Ilayaraja own the 100% copyright to the particular music that was produced?
You see, in this case, rather in most of the cases, the first owner of copyright is the composer. That is Ilayaraja, is the first owner of the copyright. He then he can transfer that right because that's a tradable right. So he might have preferred to assign away all the rights to a film producer. So that is one. However, as Raghvendraji mentioned earlier, there was a 77 court judgment, Supreme Court judgment, and therefore it was presumed by that judgment, after that judgment it is there, that if there is no contract between the composer or the author, the composer and the writer, and the producer, assigning or not assigning away the copyright, it is presumed by law that it has already passed on to the producer. So that's where the confusion had started. However, that 77 court judgment was, was set aside, or whatever you may say that, with the amendments that happened in 2012. But till that time, the ownership still remains with the producer.
Registration is not mandatory, it's only voluntary. What exactly in this case happened? Navarasam song came first. It has been composed. That composition and lyrics not completely taken in the Kantara's title song. That is very famous. It's tip of my tongue. Varaharu. Yeah. So Navarasam Varaharu. Section 13 of the Copyright Act, subsection 3 says, any sound recording, any cinematograph film, infringes the copyright of existing and includes in that the entire work will be invalid to be recognized as a copyright. So if that is has Navarasam 1, entire song would have become an infringed song. No copyright for that. But court has said that no, there is a Varaharupam, copyright exists. Means there is the origin. What is the copyright? Expression as the originality. So they have done a kind of second level remix. So the originality is such that has totally put that Navarasam little tune, little words in the background. That is not showing up very strongly. That's what court said. So, what is the copyright? Like patent, you should have novelty, inventive style, non-obviousness, or commercial application. In design, originality or inventive, the novelty. What copyright? Only one originality. If there is no originality, there is no copyright. Court said there is originality in these things. Why all AI created works, there is no originality? There is a Petronius AI. It made a survey recently. It studied OpenAI, Google, Microsoft, Gemini, Bard, ChatGPT, and Copilot, all the works created. It said whatever so-called training, AI algorithm training happening, the data sets are created, tokenism happening, tokenization data sets, and AI training are learning. They first train, learn, and the output is coming. Output is nothing but 85% is a plagiarism. Makki ki makki copy, Hindi bolte na. Slavish copying that is happening. Bloody, there is no originality. And then the commercializing it, Berne Convention Article 10.2 clearly says, exception available for the lawfully made available copy. NULS library, you go and borrow a book and your education exception, research exception. From where the book is a pirated copy? Madam, do you have pirated copies in this? No, lawfully acquired copy. They have bought the copy. From there only you get exception. Even the radio which they are playing, you will go and seek license. When performance license, lay low. They will say, no, I illegally download and playing. I have not bought it, I will not pay. One professor said this. मैंने उनको डांट लगाया था legal academy, and people were silent. I felt so bad. When if somebody is silent, means supporting him. And what he can teach in the law. So I went out of that WhatsApp group. I don't want to be in an illegal group. There may be top famous academics must be there. So something goes against law, that is wrong. What court has given, there is no originality, they say. So there should be originality, it has that. So AI, there is no originality. Even someone has given, even on Copyright Office India, by mistake they given co-authorship. It is, definition clearly says two persons, person means natural person. Is it a person? No. Then one guy is there, argues that, no, it's unethical. You are not written this. What this is writing, Petrologist A survey said all copying only. Even tunes are made. Tunes are made from where it is made, from where it is writing. Existing database, it does text data mining, pick up the tune, pick up the words, everything is producing as if it is original. Even painting, everything is copied. So it is called multiple source copy. In the plagiarism, multiple source plagiarism happens. Intelligent girl models pick up all the phrases from other boy or a girl. They put their own language and they pass on as if they have written that without any citation and that. Entire AI producing illegally without a license and consent. So yesterday only I came to know that an EU copyright societies have started giving licenses to all these jokers. You take license. We don't wait for the court decisions. Take license. And because you take subscription fee, you're commercializing and using our content that is without consent and compensation. Originality test passed by this one, Kantara song. It has survived. Otherwise, you should have been forced to take down that song from the film. That is a different thing. Yes.
So we come to the end of this brilliant session. So thank you. I would like to thank from my side as well as from the organizers for the heartfelt, very intense discussion we've all had. So thank you to all three panelists. It's been brilliant being here. So over to the OC.
A big thank you to the panelists once again. Your insights have been truly invaluable, sirs and ma'am. With that, I request our moderator, Dr. Adra PS, to hand over the mementos to our panelists as a token of our appreciation. Thank you, ma'am. I now request Advocate Rahul K, Secretary of the Nuals Alumni Association, to hand over the memento to our moderator, Dr. Adra PS, as a token of our heartfelt gratitude. Thank you, sir. With that, we come to the end of the session. Thank you very much, and you can. Thank you, everyone.
Thanks. Thank you.
Thank you so much.
Participants, the next session. Yes.
Yeah. Hello, am I audible?
Hello, Ashwin. Can you please tell me if I'm audible?
We can hear you.
Okay, great.
We can hear you.
Ma'am, I hope I'm audible. Very sorry for the inconvenience. We had to change our seating position a couple of times because, because of the noise director. Yes, ma'am. So, we're ready to begin. When you guys are ready?
Yeah, begin.
Okay. So, we'll start. Ashwin, can you start? Right. Yeah. So, okay. So, this next session is another panel discussion on the very interesting topic of licensing in the digital age. Music sampling and remix culture, legal boundaries and creativity. We are delighted to welcome two distinguished legal experts from the music industry, Ms. Ajita Pillai and Ms. Sandhini Sharma. Their extensive knowledge and experience uniquely position them to illuminate our discussion on this topic. Ajita Pillai from the batch 2007 to 2012 is a member of the Nuals family who is currently working as a senior counsel for a global company in the media and technology space. Our next speaker, Ms. Sandhini Sharma, serves in business and legal affairs at Sync Music Group and is a certified information privacy professional. Ms. Sharma is a Master of Laws in Media, Entertainment, Sports and Technology Law from UCLA School of Law and is a licensed attorney in both California and India. Passionate about the intersection of music and other media such as TV, video games and podcasts, she is committed to empowering artists and creators in the dynamic and evolved digital media landscape. Ms. Sandhini Sharma serves in business and legal affairs, Sync Music Group, like I mentioned before. So, please join me in extending a warm welcome to our esteemed panelists as we commence this insightful conversation. Over to you.
Thank you, Adil, for this introduction. Hello, everyone. I'm Ajita Pillai. I'm part of Nuals. So good to be back here presenting in this conference. First, let me congratulate all of you for pulling this conference. I can see it's a massive success. Well done to everyone. I would like to thank our activity, our registrar, our teachers, Sir Jacob, Sir Hari, Sir, everyone who helped in putting together this conference, and all the students who volunteered to make this conference happen. Thank you, and especially thank you to Nandita for giving me this opportunity. It's truly a privilege to be part of speaking among these prestigious panelists and other presenters. Thank you for having me here today. I know it's 7 p.m. Thank you for staying back, and it's pretty late, but we hope we could spark some curiosity on statutory licensing in the digital age among all of you. So today, my co-panelists Sanidhi and I are going to talk about statutory licensing. They have implemented statutory licensing since the Music Modernization Act of 2018 in the US. And my co-panelist Sanidhi, who is well-versed in music remixes and also music sampling, will speak about its implications in this current licensing regime, both in US and India. And then we will open the floor for questions. So the structure is that me and Sanidhi will speak for 20 or 25 minutes each, and we hope to conclude our conversation in the next 40 to 42 minutes and then open the floor for questions. So I'm going to begin my topic, which is statutory licensing in digital age, and Sanidhi will join after. So what is statutory licensing? I think an introduction will go a long way because it's something very specific. Though it comes from the Berne Convention, the way it's drafted into a statute is very unique. So let me tell you what is statutory licensing. To understand what is statutory licensing, let's take a step back to understand what is voluntary licensing. Now, voluntary licensing is like a usual contract that happens in a free market scenario, right? So rights holders, which is usually music labels or indie artists or creators, come and do a voluntary agreement with broadcasters like televisions and radio and even digital streaming platforms, where the terms of agreement are negotiated in terms of what is the royalties that the creators will be getting paid and everything, and it will be formalized into an agreement, and that is recognized in our Indian Copyright Act of 1947. That is voluntary licensing, much like a usual contract. There is a quid pro quo, right? So the broadcasting agencies get catalog of music or video that they can broadcast, and the creators and copyright owners are paid an amount of royalty based on a mutual negotiation. That is voluntary licensing, right? Now, what is statutory licensing? In the statutory licensing, which is Section 30D of Indian Copyright Act 1957, this is specifically included to empower the Copyright Board to grant licenses to the broadcasting agencies so that they can broadcast this content without prior permission from the creators, but after fairly compensating them with the royalties or the amounts that is fixed by the IPA, which is the Intellectual Property Appellate Board. So it doesn't need specific permission from the creators, but it needs intimation and royalties to be paid prior hand before broadcasting. So this kind of provision tries to balance three types of interests, which might be obvious, but let me spell it out for you. It protects the interests of the creators by providing fair compensation to them, without which it's possible that their work could be copyright violated and broadcasted, right? It helps them with a framework to get compensated. It helps the broadcasting agency, a new broadcasting agency, a new entrant to enter the market to provide these services and compete with other existing giants. And it helps small broadcasting organization, and it helps the public. They get to listen to the right of music and video because of the statutory licensing without having to go through, which is the creators, without having to go through individual negotiation with these broadcasting agencies. So we can avoid dispute in negotiations, etc. So it's a win-win situation, right? Win-win-win situation. So the three stakeholders: public gets to access music and video catalog. Creators get to get fairly compensated, hopefully if it is fairly fixed by the IPAB. And the broadcasting agencies would have catalog of content to exhibit and publicly communicate that already published work and content to the public. So it's a big situation for all the three stakeholders involved. Now, this provision did not originally exist in our Indian Copyright Act. It's something that was included in 2012 by way of an amendment. So it's something that was wrong here because it was part of the Berne Convention, it was part of our TRIPS obligations, which treaty we have ratified, etc. So it was included much later, but it was included in 2012. So now that this is included. The statutory licensing was included in 2012. I would like to speak to you about how it has impacted the radio and broadcasting organization, because we have proof of concept there, right? Because it's been more than 10-15 years that this provision is in existence, how it has really impacted the radio and broadcasting organization. I would like to speak to briefly about and then segue into the digital space. So if you take how it has impacted the radio broadcasting organization, so it was only once after the enactment of the statute, so IPAB had passed orders on what would be the royalty that is paid to the creators, which was 2% of the net advertisement revenue. That is, if it's a small FM radio and plays song only in Kochi, and if it has advertisement revenues, right, 2% of that net advertisement revenue would be paid as compensation to the creators. That was the said rule that was published by IPAB, and it was followed for a very long time until 2020, when it was overhauled to include a more nuanced approach. Can you imagine a situation that for 10 years, the royalty rates published by IPAB was in existence? It was at the minimum not even adjusted for inflation or CPI index. It did not necessarily take into consideration the advent of new technology or having multiple radio stations which has different radio stations, right? Some are national FMs, some are regional FMs, some has music content plus news which they broadcast, etc. It did not take into any of that into consideration. It just had a flat rate of 2% of the advertisement revenue, and that had existed for 10 long years. Only in 2020, IPAB overhauled that system and thought that advertisement revenue, the 2% advertisement revenue, is proving to be a very small compensation. When I say 2% advertisement revenue, you might think it's a big number, but it's not. When it works out to actual calculation to be paid to the creators and copyright owners, it was a very small amount and they did not get fairly compensated, right? So IPAB thought it's a good process to overhaul the whole system of the advertisement revenue as the compensation mechanism, and came up with something called NPH, which is needle per hour or play per day. What it simply means is that the broadcasting organization should compensate creators based on the actual consumption of the content. Because if you take advertisement revenue as a standard to calculate royalties, with no fault of the creators, if there is a mistake done by this broadcasting organizations, right, a business mistake or some stupid business decisions would mean less advertisement revenue, and that could impact the creators for no fault of theirs, right? So the whole advertisement revenue as the end-all solution did not sound fair to IPAB, which I agree with that interpretation. So they came up with needle per hour, which is a more global standard to understand, to pay compensation based on the actual consumption of the content. So that was done only in 2020. And for 10 years that the whole model existed where creators complained that they were inadequately compensated. When it comes to digital streaming, let me jump into digital streaming, but I have to tell you that when it comes to musical works, digital musical works or non-digital musical works, you should be familiarizing yourself with two terms which I will use during the presentation. One is the sound recording, the other one is the publishing right. Sound recording is the actual song which the creators get compensated, and publishing rights, more colloquially referred as publishing rights or mechanical rights, is the compensation that the lyric writer and the tune composer inherently gets compensated for in a musical track, for example. So both of these rights go hand in hand. Sometimes it coexists with the same owner, not necessarily always with the same owner, right? So this came into consideration during that 2020 IPAB order as well, and the IPAB ruled that this type of compensation, that is needle per hour or pay per play, which is the rate of consumption, should be considered for all works, which is including publishing work and sound recording. But immediately after that ruling, Delhi High Court ruled that IPAB doesn't have the power to speak about publishing rights because it's the inherent sound recording owners who should also distribute the publishing rights, etc. So there was a long shadow cast on this rule already. So a simple takeaway that I would like you to have as part of the IPAB ruling is that it was too little, too late. The compensation was fixed after 10 long years, and it did not even provide clarity on the rights that will be compensated for. This is specifically for the radio broadcasting industry, right? Statutory licensing as an intention is a good provision, right? It creates a win-win situation for all the stakeholders involved. But practically, the way it was implemented, if I have to be blunt about it, it was botched by IPAB. The rates were never re-looked at. It was not even adjusted for inflation. They didn't have clear jurisdiction on what is the type of rights they are ruling. So who are the losers, right? So it is the creators who got fairly, who could not get fairly compensated, and the broadcasting agency were able to still use their content and disseminate to public, but the music creators, especially the small ones who cannot afford big labels to do these negotiations for them, were affected. When it comes to radio broadcasting. So now let's go to the digital statutory licensing space, right? In the digital space, the current position is that the statutory licensing section in the Indian Copyright Act does not apply to the digital streaming platforms at this stage. I'll tell you why. So, what happened in 2016 is that the DPIIT published an office memorandum. It's not an amendment to the statute. It's not an amendment to the statutory rules under the Indian Copyright Act, but only an official memorandum. They published an official memorandum stating that this provision, which is statutory licensing, also applies to digital or online streaming platforms. So what is a digital online streaming platform? It's a platform which uses internet to disseminate already published work like music or videos, right? Music videos or just music, audio. So they say it applies, the statutory licensing applies to a digital streaming platform like Spotify, Wings, or Apple or Amazon Music as we come to know today. So based on this 2016 office memorandum, Spotify tried entering the Indian market. So they said that they could apply for statutory licensing from the Copyright Board, but Warner Music disagreed and sued Spotify for copyright infringement. They said the statutory licensing provision does not extend to the digital platform, so they sued Spotify for copyright infringement. But the matter was ultimately settled between the parties, and the position of law remained open, right? Only in 2022, when Wings was sued by Tips for copyright infringement, this law was settled by the Bombay High Court, in which the Bombay High Court said the statutory licensing provision does not apply to the digital platform. So various reasons. Some of the reasons that the court cited is that if you consider radio broadcasting, there is very less consumer choice, right? You cannot ask radio to play the songs you like. Sometimes you can during the specific hours. It's up to them on what music they play, right? And there is no way that you can go back and download the music that you listened or create a library of music that you already listened during the day, etc. And they also use their platform for dissemination of other information that might be useful to public, like traffic updates, news, and whatnot, right? So they said that's inherently, the court said that's inherently different from an online streaming platform, which allows you to download music, go back to the music you like. So it's very different type of dissemination to public of an already published work. And if the legislature intended to include digital or internet service platforms, it would have done so under the section, under the Indian Copyright Act when they made the amendment in 2012. So on that basis, the Bombay High Court said that the current provision does not allow statutory licensing to be extended to digital online space. Interestingly enough, in 2024, in August, which is just a month back, the DPIIT removed the office memorandum from its website, maybe signifying its adherence to the Bombay High Court decision that the provision currently does not extend to digital platform, right? Now, it has, the Indian legislature has few things to do before it could extend it, right? So the current provision doesn't seem to extend because it's not drafted in a way that it extends to the digital platform. So we might need a legislative overhaul on what statutory licensing would mean to the digital age. That enactment is much needed if we have to extend it. So let's think about, should the legislature extend it? What is my view on it? And what are the merits and demerits of statutory licensing in the digital space, right? If you take statutory licensing as a concept, it squarely fits in, theories that I personally like a lot under the intellectual property right law, which is the Locke theory of sweat of the brow theory, that you have to compensate the creators for their work fairly and also balance the interests of the public in communicating that work to the public, right? So the balancing act of making content available to the public and also fairly compensating creators would mean that this content will be available long term to consumers, right? And it also, if the entrance is the bar to entering a new industry like a digital media space is low, many players can come in, which would mean better competition, which also means better content for consumers like us, and we can avoid a lot of monopoly and oligopoly, right? So the intention of statutory licensing is quite laudable. It might be particularly helpful for small artists, right? Indie artists, big artists, Taylor Swift, everyone has big labels to back them up. But when it comes to small indie folk artists or small regional artists, they don't have the backing of big labels. So statutory licensing would help protect their work, right? In the sense that without that, broadcasting agency could just play their song, use their song, and not compensate them. And it might be a burden for them to undergo the litigation expenses to sue these platforms, etc. Right? So it really helps small indie artists to exhibit their content for a fair compensation, and it also helps the digital platform to have this variety of music without having to go through individual negotiation, and it helps consumers, right? Who doesn't want to listen to an Afro pop, right? Like I listen to Afro pop a lot. I'm sure you have your own music works from different regions which you would not have heard if not for these digital platforms. So it definitely creates a more democratic situation where we can have access to different kinds of content. So the intention behind statutory licensing is quite laudable. But what did we get wrong? What did India do wrong, right, in my opinion? Because in the last 10 years, if they're only home and if the IPAB does not understand the importance of calculating these royalties on a periodic basis to protect the interests of creators, then the creators are at loss, right? Clearly, how the way the statutory licensing has applied to the radio broadcasting industry has taught us that it was not implemented well. So if we want to extend to the digital space to protect rights of parties who doesn't have the level playing field with that of big labels, etc., then we need a statutory licensing framework that we have in the US. So in the US, after the Music Modernization Act, MMA of 2018, a collective, which they call as mechanic collective rights, they have constituted a statutory body which does three things. One, it takes the rights, especially the publishing rights, which they are compensated even less when compared to sound recordings. They first take the content in, register the content. Then they get royalties prepaid from all the music labels and publishers in advance for the year. And then, based on the consumption of their music, they distribute that to the creators. So it does three roles, right? It takes the content, it takes the payment from the music labels, and it distributes that payment to the creators. This means that the streaming agencies cannot escape from the liability of payment, which makes it more democratic, right? A creator can log into that website and see how the song was consumed and would be entitled to the royalty payable by that calculation, right? So it creates a more democratic situation where all stakeholders involved are benefited. So unless we can have an MLC type situation in India, a more proactive functioning IPAB and copyright board, extending statutory licensing to the digital age would be a nightmare, which would only mean that indie artists and small creators would not benefit from it. So we have a lot to think through before extending the statutory licensing in the digital space. That's all from me for today, but I'm going to let Sanidhi speak. I hope I didn't take a lot of time, Sanidhi.
So, Advait, do you want to say anything in between, or can I go ahead?
Ma'am, you can go ahead, ma'am.
Or if there is anything particular that you want me to address apart from the topic? I guess that's a go ahead. So, talking about another portion.
Ma'am.
Sorry, you're not audible.
Audible, ma'am?
Yeah.
Am I audible, ma'am? Hello? Yes, ma'am. So
Yes.
I just wondering we could take this in a conversational tone between the both of you. It's up to you, ma'am.
Yeah, sure, we can do it either ways. So, yeah, like Ajita just mentioned about one portion of statutory licensing in India, which talks about the broadcasting part of the music. I am going to speak about another version, which is 31C of the Copyright Act, which talks about cover versions of sound recordings. So in this version, and just to revise what she just mentioned, when you hear a song, there are two parts in it. One is the sound recording, the part that you actually hear it, and another is the musical works, which is the lyrics and the composition that go behind the sound recording. Now, there are two separate copyrights in a song, which is the sound recording and the musical works. And whenever we look at a song, we look at two different sources of earning and two different assets in one. So that is something that I didn't know when I was in law school, so I just hope this is something that everyone who is ever interested in music needs to know about. So now I'm going to talk about cover versions. Cover versions are basically recreations of sound recordings that you hear or of musical works at times that you hear. Cover versions are something that you see these indie artists, especially with Instagram and all the reels being a huge source of popularity these days. These are the kinds of, I would say, sources of entertainment that really help indie artists get recognized, because they are trying to use songs that have a huge following, huge fan base, are currently trending, and trying to portray them in their own voice, in their own style, to get popularity, to get recognition for their songs, etc., their singing skills. Cover versions under 31C are legally allowed to be made in India, but I think the restrictions over there are a little too strict on the creators, and one could say from a jurisprudence perspective that they are protecting the artists. And why I say is that legally in India, a cover version can only be made 5 years after the song's been released. Technically, the song by that time has stopped trending. People have moved on to new genres, new songs, and like we know these days, our attention span has gotten so small that we all just switch to things in a minute. And if there's a restriction of 5 years, it can definitely hamper the artist or the creator that is trying to show off their singing skills, trying to get recognition. And apart from that also, I think from a label perspective, it is a good thing, because again, I want my particular sound recording to get the recognition, I want to get the streams, I want to get the revenue out of the song. But the moment a cover version is made, and nowadays especially I see that investment I made in the artist, in the song, etc., label or a creator, if they own that particular sound recording and request that, okay, I'm going to make so and so cover version of such a song, they can provide them copies of that song, they can provide them advance money if that's required. Previous song was released. So nowadays it doesn't really make sense to have this language, as well as the digital forms, which is you hear on YouTube, Spotify, etc. So ignoring that part, if you take a look at just the regulation part, I think that we should try to balance it out and make it to 2 years or something that actually helps both the artist and the label to generate revenue for the investment that they have made and the original work that they have created, but also help these indie artists to make cover versions. Because the cover versions that you hear right now on Instagram, they are really an infringement of the copyright of the original work. And people, even though that they are monetizing, but coming from a company like T-Series, I would say they are taken down as soon as they hear of such a thing happening. As you can see on YouTube, especially, I think Yash Raj is really notorious for these acts of taking down videos as soon as they hear a single clip of their song. So that is 31C of the statutory licensing. Now segueing into another part that's becoming really common in the music industry these days in India is sampling and the remix culture that is there. So just to give you a brief overview of what sampling is. Sampling is when you take a portion of a sound recording or a musical work and then use it and create a new version out of it. Now, the biggest examples are Toxic by Britney Spears, which has a Bollywood song. The music is there in the very intro, and there are a number of songs that actually use these. I'm not really familiar with a lot more examples to give you, but yes, this is something that is happening very often and very widely in both the music industries in India as well as in US. I see so many cases where people are using certain parts of a sound recording, a certain beat there, a certain music part that they really like, and then making a completely new song out of it. The major issue here that the courts see is, first of all, there's nothing really that's been legislated around this topic. So our Copyright Act does not really talk about sampling. It does not talk about how the rules are around it and how we can do it legally. But in India, they're just using it case by case as well as just taking the principles from the general copyright law. If you take a look at this, that actually leaves you in a very tough state being a creator, being an indie artist, which does not have deep pockets to go around, sample a particular portion of the song, use it in your own, because the moment somebody who is the original owner of that song gets to know about it, they are going to claim. They are going to claim the royalties, they are going to claim the ownership, they are going to claim all sorts of things under the sun that you're going to do with that particular new sound recording. Now, just to make sure that we are all on the same page, sampling, when the courts take a look at it, they see almost three things that are there. One, whether the first original work is a copyrightable work. And when I say copyrightable, it means that it's original, it's something that they made on their own, it's not something that's easily available in the public domain. By public domain, I mean something that is outside the purview of copyright, that protection for copyright has expired, or it's actually something that's a folk. All the folk songs come into the public domain. Now, so when the courts take a look, first thing that they see is even whether the original song in itself is copyrightable or not and is owned by someone or not. The second thing then when they see is that, so what's copying done? Now a lot of times, and I have seen this in the US more, that when a copying is done, the courts pay attention to what copying actually is. And by that, what it means is, nowadays everything is very much accessible. You can even listen to songs in Africa and in Andhra at the same time. So people have wide access, there's global connection everywhere, but that was not the case before. So when courts were hearing a case of sampling or copying, the first thing that they saw was whether the other party, the infringing party in this case, has even access to the original song. Let's say if there's a song made in Paris, and there's somebody who in Dubai who's making the same song again, or using some beats that are very similar, the court will always pay attention to whether they even had access to the song. Second thing that they would see is there are certain beats that are very necessary in making of a song. I am not a music expert, but I can tell you that there are beats, there are bass trails, etc. that are exactly similar in a lot of songs because they make up a huge part of the song. So you can't really assert your copyright ownership over those parts of the song, right? So these are the things that the court really looks at when they are seeing whether it was copying or not. And then the third part that the court looks at is whether it was a substantial part or not. Now, substantial part is not something that can be defined by also from a 3-minute sound recording, 2 minutes of it were copied or 30 seconds of it were copied. Depending on how memorable, how distinctive, how unique that particular portion is that has been copied, a court will make a judgment on whether there's been a use of substantial part or not. And what I mean by it, there are case laws in the US where a simple thing as a 4-second to beat usage has been called substantial, but there have been cases where a huge part, like a 10 or 15 seconds, similar sort of music has been used in 2 particular sound recordings, but the court has said that no, it's not a substantial part. So again, I would say, especially in the case of sampling, I know India doesn't have laws around it and the artists are really trying to create something unique. But my 2 cents would be to always go for licensing in these cases, not to really support your claims on the basis of fair use, which is fair dealing in India under Section 52, which basically talks about all the different categories under which a person can use a copyrightable work as well. And then another defense is de minimis, which is that the use is so trifle, it's so small that the law is not really going to concern itself with it, right? They are good defenses. They are actually used by a lot of labels when cases similar to these come up. But being an indie artist and having limited resources, I would say this is something that would depend on the mood of the court that day, how they are really listening to it, because music is something that is really one's own unique perspective. There's something that you might find similar in two songs, and there's something that I might find similar in two songs. So this is something that is left to perspective of the judges, which is again a very risky call. So I would say definitely to go for a voluntary licensing and get the clearance out of the way. And why do I say it? Because I can't name the particular song, but there's a current conflict that I know of where with my own company, where the song was released, and I think there was a very, very light chant in the background going by champ, 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 etc. And that is something that a layman like me won't be able to even understand, since I haven't even heard to that, or I haven't even heard that original song. And the other party is claiming that they used our chant in the background, which really made us worried, and we tried to listen for it, and then we could hear certain noises in the background saying champ, champ, champ. And the problem here that actually arose for us was that the song did so well, which was something which is again a gamble. Whenever a person makes a song, they don't really know how the audience is going to perceive it, what revenue it's going to generate, etc. So yeah, when the song came out, nobody knew that it's going to be such a huge number and we'll be collecting money from all over the world, etc. And this person comes up, and now a simple sample clearance, which would have costed somewhere around $100, $200, etc., would now actually depend on the revenue that the song's generating and certain percentage of it, which again is risky for the label, for the artist, for everyone in the mix. So that is my view of sampling. Remix again is something which is new, and since I've worked in T-series in my previous job, I would say that is more normal now than before, and they're really into recreating and remixing all these songs. And similar to sampling, remixing again is something that is being done by the labels themselves, who have huge libraries, by the remixers that are new and coming up. Like you can hear Tesher, you can hear DJ Chetas, all these people are coming up with their own versions of a lot of songs. I've recently started listening to this artist called Farouk, who's making all these crazy numbers, mashing up 2 or 3 songs together or using beats from different songs, which is again a great and a creative way to express and definitely garner the attention and get the audience. But again, the problem here is, and from an Indian perspective, a person before going into it, even a label for that matter, even when labels like Saregama or T-Series make these songs, the first thing that they need to check in their agreements with the creators, the original creators, the producers of the song, is that whether or not they have adaptation rights. Now, adaptation rights are something that allow you to make, to buy, and when I say make, I mean to alter, to change the arrangement of a song, to make it different, to make it unique, to make it in some other medium than it was in originally, and go about it. It is very similar to the concept of derivative works in the US. And if labels have to take a look at it and check the rights before they go into it, I think remixers, the indie artist, or any creator who's up and coming in the space should definitely make sure that they have the correct licenses, that they have all the clearances that they require, because in the long run, it not just hampers the revenue that they might generate, it can actually bring huge lawsuits, because there are parties involved both on the musical work side as well as the sound recording side that get affected. Their royalties, their revenue gets affected. They becomes huge one day. That is when you start to see the domino effect of all these different remixes.
No, I think we covered statutory licensing and specifically on music sampling and remixers, more specifically, right, both on compulsory licensing and statutory licensing bit, or is it the person who gave the right command to feed, or is it the person who gave the right command to feed this into generative AI? What is the division of labor between them? What's the proportionality of compensation that both of these parties deserve? Whether they have to take permission from the original provider before venturing into creating a generative AI-related content is all open question currently. So it will be very interesting to see how that pans out, right? So we are only speaking about digital age, but the world has moved ahead and started speaking about AI and generative AI, which we have to catch up as a jurisdiction. That's really my concluding remark. But Sandy, add something or if there are any questions to take?
I'm open for questions at the moment. I think you can just add on.
Right, then let's open the floor for questions with the permission of the panelists.
Please do.
So we'll have Ashwin presenting the questions that the participants have sent in during the course of this session. He'll be presenting it, he'll be screen sharing the questions on the meet, and I will be reading them out.
Sure.
So Ashwin, can you please screen share the questions? Right, so this is the first question that we have. When we talk about licensing and IPR, a similar but a different term, assignment, comes into picture. Could you please highlight the difference between license and assignment?
Yeah, please, go ahead. I'll add on to it.
Okay. So licensing and assignment, that is actually a good question. And a lot of times in India, let's be honest, from the work that I have seen, they are used interchangeably, even though they're not. Licensing is something that's done for a temporary time duration. It's done for only particular set of rights in an IPR, in an intellectual property. Whereas assignment is for a perpetual sort of duration or for a time period that is as per the copyright protection of the laws that are stated in India. And in assignment, the other person, the assigner in this case, parts away with all the rights in respect to that particular property. It could be a song, it could be a musical work, it could be a video, anything. And in that particular case, the assigner most of the times is not left with anything. They part with the rights that they have given. And in case of licensing, the rights revert back after the period of time that it has expired. Aditya, you can add on.
Sure, and sometimes assignment, like Sandy rightly pointed out, could be for recouping whatever money that they made. Practically, if you're an indie artist, you spend all your money doing this project, you just license and assign the work completely towards a music label so that you can get the money upfront, right? If you license it, generally you might get rolling out royalties on a periodic basis, but sometimes assignment might help with upfront payment. So sometimes we have seen small artists take the route of assignment.
Right, thank you, ma'am. The next question is to Ajita, ma'am. The question is, can you elaborate on why digital streaming cannot be included under the definition of broadcast?
I actually think that the broadcasting definition should include digital streaming, and it does not need a specific amendment, unlike how the Bombay High Court opined on. So if you talk about digital streaming, it does broadcast rights, right? It broadcasts different works and we can see it. But the court differed with the following reasons, and I can tell you if I agree or not agree with those reasons. Some of the reasons that they pointed out, the court pointed out, is that both are fundamentally two different platforms. If you take radio broadcasting, it doesn't have features such as downloading some music or playing music as per your request, and it also has stream share for other type of content such as news, traffic updates, etc. Right? But if you take digital platform, there are many rights given to the public, not just disseminating information. You have some rights that comes with the platform access, such as downloading the music you like, creating a library of music that you like, sharing that music video, etc. Right? So from that sense, the court opined that Broadcasting is more to communicating to the public. That's what the radio does. But digital broadcasting or digital services is specifically designed for the interests of its viewers or customers, which doesn't necessarily broadcast rights, but provides a music service based on the interests of those customers, is what the quote defined, right? I disagree with it for two reasons. Because digital broadcasting is very similar to radio broadcasting. If you talk about non-premium subscription in an audio streaming platform, it doesn't let you download music. You cannot skip music. You cannot go back to listen to the same song that you just listened. So there are quite a few restrictions, like a radio type restriction that you would face as a customer. Sometimes you're interrupted with ads, etc. So it's much like a radio, right? I do not know if court considered, free tier subscribers to digital broadcasting services before finding that digital broadcasting is not disseminating information to the public, because each of these platforms work very differently, and some of them, as a starting tier or free tier, provides really comparable services to radio. Sometimes the music quality could be arguably better, but it does one and the same. So in my opinion, digital broadcasting is one and the same. It should be as part of the broadcasting definition, but in order for us to extend statutory licensing to digital broadcasting, we should ensure that there is a functioning IPAB, which revisits rates on an annual or 2 years once basis, which provides fair compensation to the creators and comes up with a compensation model that is amenable to the platform. Right? There are two types of streaming platforms and how the revenues work. One is a subscriber-based platforms, which relies on subscriber payments for their revenue, and there is other platform like YouTube, which relies on advertisement revenue. These are the two broad, revenue models of streaming platforms currently. So, if IPAB can consider both of these models and come up with royalty rates based on these models, which is fair and which can be revisited from time to time, then statutory licensing will definitely help small players who want to onboard their music to digital broadcasting. So, to summarize, I know I went through a lot of details there. To summarize, I think digital streaming is broadcasting, and it should be made operational with these areas.
One thing even I want to point out in the previous question is that another thing that is different for a digital streaming platform as compared to radio and TV platforms is that when you stream a song on a digital service platform like Spotify, YouTube, etc., they are making a copy of that song. Even for a temporary purpose, they are making a copy of that song on your device, for which there needs to be a separate payment. And that is the reason I think the courts are really reluctant to compare them with a radio and a TV, because again, when there is an additional use, an additional right under the Copyright Act, then they need to be fairly compensated, the labels and the artists, for that particular part. So I think even when in the future they do add digital streaming platforms to statutory licensing, their royalty rate should definitely differ from what are currently mentioned for radios and TV.
Okay, thank you, ma'am. The next question that we have is this one. US concept of work for hire versus the Indian copyright concept of contract with service.
Okay. Yeah. So the US concept of work for hire, now that is something that I got to know about after coming here only. That is something which basically allows the labels, the producers, etc. to hire the artists, the musicians, everybody who works on a particular sound recording or a music video to give their services, get paid for it, but as
seen contracts with big labels where huge artists who are trending, chartbusters have negotiated for copyright version.
All right, ma'am. Thank you so much. This will be the last question that we'll be taking due to time constraints. And the question is appointing someone as a distributor of your music in US an assignment or license in general? Is there a transfer of ownership on US law, copyright, other than only assignment or license, like
Okay.
Yeah, so I would say whenever you hire a distributor for exploiting your songs on all the modes and mediums, it's a license and not an assignment. And most of the times it's even termed as a distribution license agreement. So that is the first part, because assignment again is only for a record label and mostly done in recording agreements. Or after you have already completed the work, and then you are assigning it to a label. By that I mean a major label like Sony, Warner or Universal or any of the indie labels, and asking them to use it, distribute it and exploit it. Only then assignment is used. Otherwise, when you directly approach a distributor, it's licensed. And then is there a transfer of ownership? Yeah, Adita, do you want to add something?
Yeah, sure. So, you have to understand practically it is the owner that works with music labels and music labels work with the distributor of music, right? So, this is how the transaction goes. So, if you're an artist, you try to find Sony's, Warners of the world, trying to assign your work or license your work, who then creates an agreement, a royalty agreement with the distributor of music like YouTube Music, Spotify, Amazon Music or Apple Music, who then disseminate the content. So the primary contracts in general are always between the copyright owners and music labels. And music labels have the most in the industry, right? So they have most to lose and most to win when it comes to the music industry. They kind of own the industry, right? The distribution platforms are I would say at the mercy of these huge labels in terms of disseminating that content. So when you assign or license your work, it's mostly towards the name. I know there were many questions. We didn't get to answer all of them.
we do have some time constraints earlier to other side.
Yeah, so if anybody has any questions, they can reach out to us on LinkedIn.
Yeah, on LinkedIn, we're happy to answer. I think we got through only 4 and there were 7 questions, kind of feedback that we couldn't get to it, but if you can send us the question, we can even type out the answers which you can circulate.
Right now. So with that, we come to the end of today's Q&A session and the session. I have Ms. Ananta Narayan here with me. I'd like to hand it over to her to speak a few concluding words.
Hi Sanidhi, hi Ajita. So it's not really a concluding remark or anything. It's just me marking my appreciation for you guys to take your time out, especially Sanidhi, and both of you are all, staying in other countries, so I can definitely understand the time difference. So thank you for taking time out. Sanidhi, we haven't met personally, but it was a wonderful session. Raji and me Adita and me are classmates, one of my very close friends. So thank you to both of you. Ajita, thank you so much. So hopefully we connect in the future, Sanidhi.
Sure.
Thank you.
Thank you.
Thank you, Aditya, for the opportunity and the questions were great. Thank you for participating at 8 p.m. Thank you, everyone.
Bye.
Thank you. Bye.